my advocate on record to come back and re-mention this matter, my lord. This is a cooperative matter, my lord. This is the gentleman who was elected in a cooperative society. A notice was served on him for relegating his right to be a elected board of director, my lord. That date is fixed on 19th of April, my lord. That is next Saturday. The entire next week, lordship knows that there will be fragmented. It's a broken week. Only 16th and 17th there is a court. There is some urgency in the matter.
What is the urgency?
Urgency, my lord, I am an elected member. If without even hearing me, without even knowing what is the reason I am being removed on 19th, I have a right to be heard.
How will you be removed?
Because there's a notice that has been issued, my lord, recalling my election. I am no reason assigned, my lord. That is the urgency, my lord. I will come and try and, my lord, canvas the real grievance if the matter is upgraded, my lord, and taken up on 16th or 17th, whichever day, my lord. Because
Which
these
is
are
your
the
item?
item number 1195 of your lordship. That's the last cooperative matter in
Next
the monthly
Thursday.
list, my lord.
Upgraded. Next Thursday, it will be upgraded.
Deeply obliged, my lord. I'm mentioning upon notice, my lord. My other side is also here, my lord.
Why are you here today?
No, my lord, my request, my lord, is that the item number today's item number 11 under the heading urgent motion, my lord. It was item number 2 yesterday, my lord.
I can't help that. Whatever is there, maybe some other matters have come in because of the returnable dates. I can't.
No, my lord. No,
it is urgent motion. It is urgent motion. It will be taken up.
No, my lord.
Oh, your is item number naturally.
That
naturally, yours is item. The others are cooperative society matters. You want
no.
matters cooperative society?
No. Upgraded, my lord. Upgraded motion.
First item.
No. Under group 4, my lord. Upgraded motions are there above, my lord. This urgent motion. That is what I am requesting, my lord. That above group 4, my lord, if my matter can be taken at priority at 2 p.m. Not prior to that.
No.
Not
your
before
item number 11 is there.
Yes, my lord.
Which is your item?
Item 11, my lord.
It is there.
At 2 p.m., my lord, I am requesting if it can be taken in priority over the other, my lord. Because it was yesterday, my lord, it was under urgent medical, it was at top. That is why I am requesting.
It is still at the top.
No, my lord, under group 4, it has gone below, my lord, that upgraded motion.
It is why I say go through the list, today's list. Item number WPA
11, serial number 11.
WPA 4679.
Yes, my lord.
Sunbeam.
Yes, my lord.
Hey, item number 1, what are you saying? It's at the top. What are you? Please check up the list, then mention, Mr. Sharaf is not expected from you. At the top. The other matters are upgraded motion. এগুলো তো কিসের upgraded motion?
They are all group 4 matter. That is what I am saying. Group 4 matter.
Your matter is item number 1 upgraded. There is no other upgraded matters. These are all diary matters. They have not been placed above you.
No, that is what is mentioned in the cause list, my lord. That item number 4 to 4 onwards will be called on from 2 p.m. 4 onwards. It is mentioned in the cause list, my lord.
Yes, naturally. Let us see. I'll call up. I'll call up all the matters. I'll call up all the matters.
Then my lord, I have another request, my lord. Last month, my lord, there are several matters your lordship
Don't
upgraded.
mention. Today is not the mentioning.
Lordship,
Yes.
The compelling circumstances, your lordship, have mentioned the matter. Your lordship had passed an order for execution of warrant of arrest. Your lordship, we have made the payment of principal amount of gratuity.
Nobody has tinkered with the list. Yes.
Your lordship had passed an order for execution of warrant of arrest, your lordship. We have made the payment, your lordship, of the
No, it's
principal amount
not
of
Friday.
gratuity.
Friday. Yes. Sorry.
Item number 6.
Your lordship, the matter is returnable on 25th of April. My humble submission that we will place on record all the documents that we have made the payment, your lordship, and we have made an application.
I've already passed an order. You have to take out an application for recalling in that case. No, nothing on mentioning, madam. Yes.
Your lordship.
With regard to item number 60, cooperative societies matter. It is top in the list, but it will not be taken up today. due to my special
What do you
interest.
want?
My lord, I want very much urgency.
What is the urgency?
Urgency, my lord, the election to be held on 22. And in the meantime, there is, my lord, 22 April.
When the matter comes here, only then you have urgency. What were you doing all the while?
My lord, it is my lord, urgency, my lord. I want to, my lord, participate in the election.
Which item?
My lord, 60. 60.
First item.
First time, but 2 days, no, it is not be taken up.
Why?
My lord, as per my lord, your lordship, my lord, special.
Why? No. Today it will be taken up.
Yes. Huh?
Yes. Up to 2 p.m. it will be taken up. First half it will be taken up. Why are you saying? Item number 1, this is in the list.
Well, today, my lord, I have no problem. My today, there is special instruction, your lordship, can let's see the list.
Yes.
So many.
File item number 60. This was not in the monthly list.
No. It is supplemental list, it will appear in the list. But
Naturally.
during the pendency of this, my lord, during the
What is
pendency
your
of
urgency?
urgency, my lord, I want to participate in the election, my lord.
When is
No
the
notice,
election?
no notice was served.
When is the election?
Election, my lord, the cooperative societies, my lord, 22 February, 22 April. So that's why, my lord, I want to only participate. As I have, my lord, I have
When
not
was the election process initiated?
initiated, my lord, earlier.
When?
It was,
When?
my lord,
Please tell me, sir.
my lord, the election process was initiated, it was postponed.
When was it initiated?
Initiated, my lord, initiated, my lord, 7/1/2025. It is, my lord,
We are in
general
the year.
notice.
We are in the year. Why have you come now?
No, 25.
Why have you come now
No, my
today?
lord, election, my lord, date
When
of
did you
election.
file the writ petition?
No, date of election, my lord, that is, my lord, date of
First
election.
of all, the list is finalized. So many things are there.
No, my lord, it was not postponed. Election was postponed.
Naturally. So why are you approached now today?
Now, today, my lord, election was postponed. I want to, my lord, participate. Only participate.
What
My lord,
participation will not happen?
no notice was served.
Why? What? No notice was served. There was no nomination filed by you.
That notice, as notice was not served, I failed to, my lord.
No. Today
My
you
lord, I
in the day.
My lord, it is, my lord, it is, my lord, specific, my lord, permission. My lord, their notice to
I'll
be
check
served
up.
all
I'll
members.
check up. Mention to I'll check up.
My lord,
I will check up. I will check up. Sorry, you have filed. When did you file the writ petition?
My lord, filed my lord petitions. I filed the petition, my lord. My lord. Yes. I filed it petition on first day of April 2025.
1st April you filed it.
2020, and during that time, there was no election.
First day. Filed বের করো ফার্স্ট You may have filed it
10th,
after
my lord, 10th, my lord, I have instruction 10th. My lord, 10th, it will appear in
10th
the
April
list.
you gave the notice filing on 1st, gave a notice 10th after 10 days, and you have an urgency in the matter.
Well,
Yes, sir.
during that time, my lord, the election was not declared.
For this matter to appear today, it's not appearing.
Well,
In the
election,
monthly list also, it is
Not taking.
this was on the motions.
well, your lordship kindly
My lord,
see the
Hearing
notice.
matter.
But this is in the motions.
If it is motion, say it will appear.
But my lord, it's
And
what is
what?
here.
Show him the order. Yes.
With your lordship, please, lordship. Schedule 4, item 4, group 4 matters not at item 31.
আমাকে এই 60 নম্বর আইটেমটা বের করে দেবে আমি চেক করে দেবো হ্যাঁ
Lordship, I come from outside, Lord. I thought that my learned friend would be there, but then I would make a joint prayer before my Lord's, Lord. But my learned friend on the other side, Lord, he has some engagement at 2 o'clock, Lord. May I beseech my Lord's indulgence
which item?
that item 31, Lord. If
Item 31 is
Okay.
from the daily list.
Yes.
It will not
If
be
it
taken
would
up today.
It would be because a detention matter, Lord. If not today,
No, you
Lord,
did
may
not
I pray,
mention the
Lord?
matter earlier.
May I
Today is not the mentioning day also. You ought to have come forward. Your junior was aware. You may not be aware. But
Lordship,
today is not the mentioning day one.
if I am aware for
And
that,
secondly, I cannot take it out
apologies,
of turn like this.
I would only pray, Lord. My learned friend on the other side, Lord, he agrees for 16th, Lord. Because the vehicles, the perishable goods are there, Lord. And therefore the vehicle.
123 order is there. It's under 123. 129.
129 order.
129. You apply for release.
Lordship,
You apply for release.
demonstrate,
Provisional release. You'll get it.
I would demonstrate before my lordship.
So you want to fight it out. So very well.
There is absolutely no case.
Sir, there
made
is
out,
an
Lord.
appeal, sir. There is an appellate provision. Why will the High Court entertain this at this stage?
Lord, the amount is huge, Lord, and then.
So that will not be a ground for the High Court entertaining the matter, sir. Anyway, which item?
On 16th, Lord, if at all my lords could hear it.
No, I can't say. Item number?
31, Lord.
What is the perishable goods you are carrying?
It is tobacco and pan masala.
Pan masala perishable.
Lordship, it is all in the open sky, Lordships.
What is in the open sky?
Lordship.
What is in the open sky?
Lordship, it's all under the open sky, under the sun, Lord, and it may perish, Lord, by time. That is why I have make a prayer.
This is covered under the food for that Food Act. What is that? Food and Supplies
Yes.
Adulteration Act. It's covered under that particular act.
Yes, Lord. Not a food.
No,
That is
I
true,
don't
Lord,
think it's
but
not.
then, Lord, keeping in view the volume, and I was never mistaken, Lord. They have not seen the route properly, my fast act.
What is the ground for detention?
The detention is that I was on when the vehicle got stuck up, Lordship, and was irreparable. Another vehicle was brought in and transshipment was there. They made the Lordship the updation for revalidating, Lordship, and with that in the e-way bill.
Within how many hours?
No, those things are in time, Lordship. The only difficulty
Then what is the ground for detention?
They say that you are not carrying a proper e-way bill in respect of that vehicle. What I'm trying to say, Lord, that they have to be validated, Lord. They have to be validated, Lord,
naturally.
on the portal, Lordship.
Naturally,
And-
if you have a e-way bill, now if there is a breakdown, it has to be validated.
It was validated, Lord, but it was all on the computer, Lord, and the transshipment
There is no
click was
difficulty
there.
if it is on the online. It is all the more easier to access that.
That is true, Lord. There are 3 columns: transshipment, extension, others. By mistake, Lord, the person doing it did it, and he typed it also that the vehicle has broken down. Therefore, this vehicle is getting the new extensions are being sought. He thought that after putting the real number, it would take up, when he takes a print, Lord, of the e-way bill, it would be proper. But to his dismay, Lord, the e-way bill which he typed out, Lord, the vehicle number did not appear there. And the extended way bill, Lord, was in respect of the same old vehicle. And I can show, Lord, that there was no movement of the old vehicle, Lord, for long time after when it was sent to the workshop, Lord. And this was carrying the same set of goods.
I
And
think
most
you are
importantly,
permitted to
Lord,
take out by way of a bank guarantee also.
most important.
I think you are permitted to release it by way of a bank guarantee also. You don't need to pay the entire amount.
Lordship, these days, bank or guarantees would also cost, Lord, for the bank to give a guarantee, Lord.
Naturally,
Because
the goods
it is
will
all
be
a-
released.
it is all
The
a
court
huge-
will not release
My
the
Lord, the
goods, sir.
judgment of this
Sir, the
honorable
court
court.
will not release the goods without any guarantee, sir. Also. In fact, the terms may be difficult for you before this court.
No, what
I
I
am
am
not
trying
sure.
to submit, Lord,
If
is
you
my
want,
Lord
I
will
can place this
consider.
matter in the list. But once I place this matter in the list, then you can't show me that I would have got a better terms there. Make up your mind.
Then, Lord, my Lord may kindly direct, Lord, if at all, if it is convenient to my Lord's Lord, that I will give a bank guarantee, get it released.
No, you
then I put
apply
the
before
matter
the
before my
authorities.
Lords.
When I will test it out, I will test it out whole hog.
Yes, Lordship.
Now, if you succeed, you succeed. If you do not succeed, then the terms may be
Then,
different.
Lordship,
Yes.
that is true, Lordship. That will automatically, it is a deterrent provision. But then, nonetheless, Lord, I came across several judgments of this
Because
honorable
you
court,
are
Lord.
bound to adhere to the provisions of the act.
That is true, Lord. It's a human computer error, nothing else.
There is an appellate provision. Prefer an appeal from that order. Very simple. Once you come across all this court will consider your prayer. Today, at this stage, unless you say that there has been a minimum error where it has been validated within 24 hours,
Several times,
there was a
Lordship.
delay of it's within 24 hours.
The only difficulty, Lord, is that the vehicle number is not appearing. Otherwise, it is all validated.
That's
same
the
invoice,
most important
everything.
thing. That's the most important thing in the e-way bill. The vehicle number. Now, vehicle number is not there. Nothing is there.
I will demonstrate before
No,
my
no.
lord's lot that how the vehicles were crossing. He had misunderstood the fast tag lot.
Very
He
well.
has misunderstood the fast tag lot of the
16
other vehicle
as
come,
upgraded.
lordship. It would be
16th as upgraded matter.
a time may be fixed. If
Upgraded matter. It will be taken up.
a specific
In the
time,
morning,
my
in the
lord, I
morning,
just
in the
received my
morning.
lord's
You in the morning, I can't fix a time for your matter. In the morning, it will be taken up.
review. I'm grateful.
Yes.
Thank you.
Lordship, may I be permitted?
Give a notice to the other side.
Yes, yes. We have he has been informed of 16th lord.
Mr. Tariq Siddiqui and Mr. Tonal Chakraborty is appearing, my lord. Today also, if they were in the court, I had a talk with them, my lord, that I will be mentioning to your lord.
DPM
I will give a notice.
Here's Mr. Chakraborty standing there. 16th.
Your Lordship, I crave leave to mention
I am grateful, lord.
serial number 1118 of the monthly list. It has serial number 1118 of the monthly list. It has been indicated that it would be appearing today, but it is not appearing in the list.
It's a hearing matter I will not take up. No hearing matters now. Yes. Hearing matters I am not taking up. It's a hearing matter I will not take up. I'll take up other matters because I have to take up the motions. I can't take up.
I just have one request, my lord. Not on my behalf, my lord. Or my lord, others are there, my lord. Himanshu is there. There are others.
Mr. Rai, do not mention on behalf of Mr. Rai. Mr. Rai, unfortunately, I must indicate that you mention for a matter and you slip in 5 matters along with that. This practice is not appreciated by the court.
My lord, my junior mentioned.
No, you will mention for a 1 matter, you will give the notice for 1 matter. You will not slip in 5 matters along with that. Very clear, Mr. Rai.
I have.
Yesterday, I found out that and I directed that none of those matters will be listed. None of those matters.
My lord, my junior mentioned, my lord, 2 matters. I mentioned
This
3
is,
matters.
you understand, there are others who are waiting.
My lord,
You cannot take advantage like
my lord,
this.
last week I mentioned 3
You
matters.
will mention 1 matter, you will give slip for 1 matter.
No, my lord,
Not for 5 matters you slip in. What do you think, sir?
No, my lord.
The court will not go through them.
My lord, not my lord, not this, my lord. My lord. Last week, my lord, I mentioned 3 matters.
Mr. Rai, I understand your anxiousness.
No, but
You do not want, you are only
my lord, at
making
the
a prayer
outset-
for your client. I
my lord-
understand that. But in your anxiousness, you cannot do something which is
That
not.
bit I did not.
Yes, Mr. Sharaf. Yes, Mr.
I'm
Sharaf.
just making it, my lord. I'm just.
And don't mention for Mr. Rai.
Not-
Yes, I'll hear you later.
not
Yes.
I'm
Yes,
just
yes.
making a request, my lord, that whatever, my lord, your lordship allows for upgradation.
Yes, yes.
My lord, suppose last month your lordship allowed several matters for upgradation. This month also your lordship has allowed. So whatever is once upgraded, my lord, let it remain in the.
It will not go out, Mr. Sharaf.
It has gone out. That is why I'm.
If it has gone out, once it has gone out, there was a mistake on the
because-
part of my officers because it was in the monthly list. Now, before the once it in the monthly list merges with the monthly list, and which, if for instance, say there are 10 upgraded matters, for instance, on a Thursday, and those are not taken up, and next Monday is a monthly list. Those will be merged on the monthly list, and on the next Tuesday they will come out again as upgraded matters. You
That
don't
is
need-
not happened. That is why I'm saying, my lord.
all
Now-
these upgraded matters which were there have come out again.
No, it has not.
I have those upgraded matters with me. Only 5 or 6 have been
Last
listed.
Thursday's list, your lordship kindly just.
I will check it, Mr.
Last Thursday's list we have mentioned also. my lord.
Mr. Sharaf, kindly bear with the court. I am not directing all the upgraded matters to be taken up in one day. They will be spread over 3 weeks. So all of them will be appearing and I'll be taking up all these matters. I will check up with I have checked up with the list and I ensure all these matters will be there. In the
That
list.
is the request.
All
But
these
last
matters will be there.
Thursday's upgraded because, my lord,
They will be there in the list, Mr. Sharaf. Be rest assured.
I know that there will be every month there will be a monthly list, and if it goes out, it goes.
No, it will not go out. It will be there. Once you succeed in
there
getting
in
an
the next available date.
yes, you see,
Because then it could
this
be a lot
Thursday
of
I placed
time.
it. This Thursday I placed it.
Yes, ma'am.
There are unforeseen situations which you cannot foresee.
Yes.
Now, next week again I'll place some. The third week I'll place some and exhaust all of them. Yes, call the list.
My lord,
Lordship, lordship.
My lord, I'm very clear, my lord.
No, you don't mention today. Yes.
Under the compelling circumstances, I am mentioning this matter, my lord. This is a motion matter. I have posted the matter on 11th of this month, on April, my lord. What happened in this case, my lord, they have taken initiated the recovery proceeding against my client, my lord. I have already, this is the only one, there is no alternative remedies available to the SCC, my lord. This is relates to the CST, my lord, Central Sales Tax, my lord. So only with regard to the, there is a mistake in the F form, they have disallowed my, they have made an addition on
Let
that.
us see, I can't
My lord,
accommodate you today.
my lord, but only difficulty is, my lord, if they, we should,
Monday, Tuesday, Wednesday you mentioned. Let us see.
Lord,
my lord,
I
kindly
can't
appreciate.
accommodate today because second half, you see, Mr. Mojumdar, difficulty is, although I've upgraded so many matters in the second half and expected that I'll be taking up all of them, unfortunately, because of the spilling over of matters, and yesterday I had taken a matter till 5 in the evening. Unfortunately, that could not be completed. Today, again, the matter has been fixed.
Yes, ma'am.
So,
Well, if possible, my lord, my
let me find out.
my lord, tomorrow, maybe 5
Tomorrow
minutes
I
time.
cannot. Tomorrow there are other matters. I
Only
cannot.
5 minutes will take,
No,
my lord.
tomorrow I cannot.
Well, it's
Well,
very-
next week I will. Next
very
week I will.
small matter, only I have to
Next
show
week
the.
I will. Next week I will accommodate you.
Well,
Come
in the
on.
meantime, they take the initial recovery. They are calling my client that they will take the recovery proceeding against my
That
client.
is pending in the list. What recovery? If any recovery is there, I will reverse it. What more can I do?
That
If
my
I
lord,
find that anything
Lord,
is in your favor, because I cannot take up tomorrow. Tomorrow is a date fixed for hearing of applications
my lord, I know,
and
my lord,
assigned
but
matters.
well, this is my humble request. If you also kindly give us 5 minutes time,
Which
I
item?
will not. My lord, this is not. It will appear on tomorrow, my lord.
No, let it appear tomorrow. Then I will find.
My lord, kindly.
Let it appear tomorrow.
We have already served the
Today
copy.
is not the mentioning day, madam.
My lord, I have already
Mention on next Monday.
the petition has
effective
been
Monday.
served, my lord. Only difficulty is in the in between there was a holiday. They did not.
Let it come up tomorrow. Let us
My
see.
lord, kindly appreciate.
the extension,
Today you are mentioning today. It's expiring today. You are mentioning today. What were you doing? You are sleeping, madam, all the while. Yes. What were you doing? When was the order passed? And what are you doing? When is expiring? Let me see the order. I can't take up today. Tomorrow it would have expired. If you are not careful about your matter, nothing will happen. I can't help you. You have taken an application for the. Where is the order? কালকে দিয়ে দাও লিস্টে অ্যাপ্লিকেশন দিয়েছে I can't fix it. Yes, call the list.
One amendment that is section 60.
Yes.
I am just notice which was given. I have just given 22nd the date of notice. During that time, my lord, election was declared. 6th. You will also kindly consider it. Any days. If 17th, if your lordship, then my lord, I have no problem.
No. Come at 2, I'll consider. Mention at 2. এটা ফাইলটা বের করে রাখো আমি দেখে নেবো mention at 2. No, let paper remain with us. Mention at 2. Means you come at 2. I'll not take up, but I'll find out what is the urgency on it.
If it is taken up 17th, I have no problem.
No, I'll find out whether there is urgency or not. Come at 2. Yes, call the list. Tako.
Is that matter order beyond that?
Yes. Set aside the entire order. Yes, I can do that.
Lordships, but now, Lordships,
I can do that.
I will place 3 Supreme Court. I brought.
No.
Lordships, they cannot challenge a classification today.
No, classification will go. I will retain the other portion of the order.
Lordship, this portion shall
And
go.
so
Others
far,
will be taken.
and so far as this portion is concerned, I will, as he insists, I will treat this portion as a show cause, and I will provided this portion will be treated as a show cause and shall be entitled to be proceeded with, provided the same is within the period of limitation.
Lordship, in accordance with law.
Yes.
In accordance. Lordships.
You issue a fresh show cause. I think it is better. Issue a fresh show cause.
They can issue a fresh show cause under 74 today. 73 is time, but 74 is with them. Let them invoke suppression on me.
No, no.
No, Lordship. Lordship, I am saying, no, that is what I'm, as an officer of the court, I'm telling the court what is there.
You are indicating yesterday that this is a very complex matter which requires consideration. But it is not that complex, sir. That is the reason I recorded everything in the order. No, on the basis of his response, they found out this. He is right. I'm not saying he's wrong. He's right. But he ought to have issued the show cause. Correct.
He has decoded.
He was suppressed. He was suppressed. He was suppressed.
Now I see it's a loss to the revenue, and it's a huge loss, and the next year the same issue as that. And that's why I'm saying,
Challenging it, the order passed under Section 73 of the CGST/WBGST Act 2017, hereinafter referred to the said Act dated 29th April 2024, for the tax period April 2018 to March 2019, the instant writ petition has been filed. Mr. Kanodia, learned advocate, appearing on behalf of the petitioner, by drawing attention of this court to the show cause notice issued under Section 73 of the said Act dated 29 December 2023, would submit that in the show cause no.
think if it is in accordance with law, they can proceed. But Lordship, if your Lordship specify, because Section 75 specifies.
This part will be excluded.
Lordship, that is specified in the law. Section 75 provides for it. If during the pendency, any decision is taken, that period is to be excluded.
75. What is the execution?
75(1), Lordships. Can you take 75(1)? वो अलग चीज है. 75(1) is yours. Where a notice, service of notice or issuance of order is stayed by an order of a court or appellate tribunal, the period of such stay shall be excluded in computing the period under
No stay.
And
there is a
Yes.
the affidavit of the affidavit and what the High Court has given the decision which is made. In some other project, the affidavit tribunal or the High Court has given the decision of the affidavit of the spend the period spent between the date of the decision of the affidavit of the and
This is a discretion I have exercised in the matter.
Lordship, your
Exercise
Lordship,
in
your
the
Lordship
matter.
may exercise
You can't
to
get everything.
Lordships, but today your Lordship is giving them direction to issue a fresh show
Not
cause.
direction. I have not.
Lordship has specified that.
No, I have said if they entitled to in law and I have excluded this period. That's a discretionary exercise. Rest
They
is okay.
specify they cannot do under 73. At least
No, why will I specify?
because
If
that
they
period-
do, you set it aside. Set aside, quash it. If they do it, I have calculated 73 is barred.
This is what Lordship. So Lordship,
So why will I provide for that?
Lordship,
In
because Lordship are
accordance
providing
with law.
the exclusion. So to that extent,
In accordance with law. Yes, next. And you have succeeded in the matter. You want the
Lordship,
department
this
not to
would-
proceed
Lordship,
ever against you.
Lordship,
That is not possible.
this would create a bad precedent, Lordship. Why I'm saying
No,
because
no.
we know department what they will use this.
Yes.
They will use this for 73. They say court has given us the power to invoke 73 by reading this. That is why I'm clarifying.
73 is already.
That is why Lordship.
It's only one day available to him to pass the order under section 73. One day was available to him. 30th April was the last date, correct? Correct?
Lordship.
So he could not, because a show cause, if he has to issue, show cause, he has to be 3 months prior to that date.
Lordship.
So 73 is barred.
Just
Now,
that is why
whether
my
74 he can invoke or not.
On that, that's my only request, that Lordship may clarify, because otherwise it will lead to another round of litigation.
I have not given them the authority.
That
No.
they would treat that because Lordships.
I'll record in accordance with law. I'll record that.
Yes.
That will be there in accordance with law.
Much.
You have succeeded here, sir.
I go
Because
down
if
whatever
this matter, Mr. Chakraborty did not want this to go through at all. Oh.
Item number 2, I am for the petition.
Yes, having heard the learned advocate respect and noting the petition contents.
I appear on behalf of the respondent.
Without service of the copy of the writ petition, let the records of the writ petition be produced. Yes.
Malad, I appear on behalf of the respondent number 5. Malad.
Yes.
Malad had directed on the last occasion to file an affidavit, Malad.
Where is the stay? Where is the stay?
Stay.
Malad, may I file the affidavit, Malad, with your leave?
No, state. 6th March, my lord.
You were not a party to this petition.
Earlier, this petition which was disposed of by Honorable Justice Prosecution.
Malad, he was a party,
I was
Malad.
but copy has not been served properly.
Malad, he chose consciously not
We
to
find
appear.
out. I have the affidavit of service here.
Yes, ma'am. Kindly see page 143 of the writ petition.
Page 149, Malad, of the
Mr.
writ.
Sen Gupta, you were there on that last occasion.
Yes, Malad.
WPA 17218, you were
Malad.
there.
Yes.
Yes.
You
I
had
was
not been served.
No.
You are not a party.
Malad,
Party. There was a party, but copy has not been served properly.
Let me find out.
Kindly see page 143 and 143.
No affidavit of service, I will check. I will check from the affidavit of service.
No. Affidavit of service of that writ petition, my lord.
Yes, I have brought forth that petition is here with me.
Yes, my lord.
That petition is here with me.
Certified copy have been annexed of this copy in the writ petition.
Who are you? What is your name?
My name is Subroto Kumar Basu.
No. Are
Society Park Street in Free Parking Cooperative Society, respondent number
Park
Park Street
Street Free Parking Cooperative Society?
Yes,
Respondent number 4 is there.
yes.
Item delivered.
Yes, my lord.
Item delivered.
No, no, my lord. Kindly see for a moment. First of all, what on the basis of the presumption of the affidavit of service, page 143, kindly see. My lord has dictated the order. But facts is this, the consignment was under lock, the door was locked, that was not given. That has been surrendered to the sender to the sender. The item consignment has been sent to the sender on 12th July. Kindly see page.
না ঠিক আছে
Kindly see page.
ইন্টারনাল পেজটা বলুন
Internal page 149, my lord. No, it's a page, page 149. Consignment, page 149, my lord.
Nothing is wrong in this order.
My lord,
You have come forward
my
by
lord,
this.
no, no, my
I
lord,
will dismiss this
my lord,
application with
my
costs.
lord, let me submit whenever the coordinate bench has passed the stay order of the.
So,
let me submit, my lord.
yes, sir.
My lord, let me submit.
Yes, coordinate bench has passed a stay order. You are not seeking modification of the order passed by the coordinate bench, are you?
My lord, let me submit, my lord.
Yes, Mr. Basu, you
Whenever,
submit, sir.
yes, my lord, whenever I have submitted 200 pages of the disposition, I have something to say. My lord, I am practicing.
What was the order?
30 years.
What is the order passed by the
My
court?
lord, I am coming.
What is the order passed by this court? What is the order passed by this court?
2nd January, my lord.
What was the order passed by the court?
Which,
You are practicing in the court
my
for
lord,
30 years, sir. What is the order passed by the court, sir?
my lord, that order relating to the consideration of the representation on 22nd.
And you will not consider that?
Yes, my lord, I am coming on that point. Yes, I am very much coming on that point. Kindly see the prayer of the, I have already annexed the petition of. Is there any prayer of the?
Refer an appeal from that order.
My lord, I am coming. My lord,
Yes,
coming.
yes,
Moment
yes.
coming. My lord, let me, whenever.
Complete it, sir. There are so many matters. I cannot hear a matter like this,
No, my
a
lord,
consideration
my lord,
matter.
let it-
You please proceed. Please
Yes,
proceed.
Yes,
Proceed.
my lord. My lord, I will proceed.
Yes.
Kindly see. Here the list of rest of.
You will consider it, presently.
On second,
please.
my lord, kindly see. On,
Finish.
yes, my lord, first order passed by the assistant registrar on 2nd January 2024. Challenging the order, society filed 2 applications. Sorry, society filed 1 application that is relating to section 142, that is review. Thereafter, my lord, respondent number 5, intending to be member person, my lord, he filed 142 of the application. That 142 application for enforcement of the obligation of that order. And 148 is review.
I will not permit you to argue on the merits of the matter unless you are in a position to demonstrate this is in the form of a review of the order. First of all, you show me that what wrong this order is there.
Yes,
you have to show me
in the said representation, my lord, in the said representation, 22nd may kindly see the representation. They have already stated that division application is pending. In this, which has been asked to consider that representation, it has been stated that revision application is pending.
Then you ought to have filed a review.
My lord, yes.
Then you ought to have filed a review.
Yes, I am coming on the point of view. No copy of the petition has been served.
So you will not file a review.
How, my lord? If the petition is not with me, I have applied for certified copy. I have stated. I have applied and I have already annexed in the certified copy of the petition. My lord, kindly see. And the matter is pending before the revision application, knowing fully well. Instead of considering the representation before the secretary, he has prayed for assistant registrar because assistant registrar quietly passed this order.
You file an application for review. This is not permissible.
My lord,
I will dismiss your application.
No, my lord, kindly see. Let it be my lord, I am assisting the court officer. My lord, as a court officer, kindly. Whenever the revision application is knowing fully well that is pending before the knowing fully well earlier at that time. Therefore, my lord, let it be considered before the secretary department of corporation.
Anything else?
Yes.
Anything else on this?
My lord, we at the same time we have challenged.
You want it to be considered before the secretary. You want this to be considered before the
I
secretary.
have prayed for also.
You want this representation to be considered before the secretary.
Yes.
Secretary of
Secretary Department of Cooperation, because we
Department of
Cooperation. Department of Cooperation, state government. My lord, Department of Cooperation one thing and Directorate is one thing. Directorate controlled by register.
Why will the Department of Corporation consider this?
Because they are
Under which provision of law?
Yes, 148(1). 148(1) of the Cooperative Societies Act.
You want to prefer an appeal from this order? Go and prefer an appeal from this order.
Where?
The order passed by Justice Chandru.
Yes.
You want to really prefer an appeal from this order? Go and prefer an appeal from this order.
Well, already we have prepared a revision application against that order.
Which revision application?
That application against 4th April 2024.
2nd January 2025. Have you preferred any appeal?
Yes, my lord.
2nd January 2025. Have you preferred any appeal?
No, because of that, we first of all there was no copy of the writ petition. Kindly see.
I do not accept the fact that there was no copy of the writ petition,
Yes,
because
my
the
lord.
affidavit of service is very clear. Item door locked, you did not go and take it.
My lord, kindly see what becomes. Yes. In affidavit service, always it is written third, and that has been acknowledged or returned. Kindly see the affidavit service.
Door locked.
Simply, no.
Intimation sent.
Affidavit service has not been returned that. In affidavit of service, it has not been written. Affidavit service has not been clear.
Have you read the affidavit of service?
Yes.
Read the affidavit of
Yes,
service.
sir, my lord. Yes.
From
Kindly
which
see
page?
page 143. Kindly see page 43, para 2,
Which page?
page 143 of the writ petition, of our writ petition.
Yes.
Para 2.
131.
Of my learned advocate. I want the copy of the writ petition along with
Forget all this, sir. Whatever is
No, no,
annexed to
my
the affidavit of service, show me from that. Don't go what his statement is there.
No. Affidavit of service of the learned clerk of that advocate, of their
Anything
advocate.
else you want to know?
Upon, for a moment, my lord. Order dated 4th and upon respondent number 1 and 4.
Number
But subsequently, what happened? Either it has been returned or it has been duly acknowledged. Nothing has been disclosed. My lord, on the Honorable Justice Kaushik Chandra only seen this served, therefore it is already received. On the presumption of that, kindly see, if it is mentioned before the Honorable Justice Kaushik Chandra that the revision application is pending, it was sufficient for that, for consideration before the secretary, not before the assistant registrar.
Why?
Because according to law, they know very well against 142 and against 148(2), both applications should be considered before the secretary. Secretary is responsible to hear the matter. It will be simple, my lord. Let it be sent to the secretary because matter is pending before there. A state is present. Would I supply?
No. A cooperative society that the আছে এখানেই আছে ওটা বের করতে কোথায় গেল
ওটা বার করো তো যে
বের করো
যেটা আপনি ওই আমাদের রিপ্রেজেন্টেশন যেটা ওখানে কনসিডার পিটিশনের যেটা আমরা বলেছি ওরাও বলেছে যে
under which provision you have proceeded to file the revision application?
My lord, 148 subsection 1 revision application.
From the order, which order?
Well, the order dated 4th April 2024. Page 85. My lord, we have page 80 and page 95 of the acknowledgement of the division.
আরে ওই অর্ডারটা ঠিক মতো পেয়েছি হচ্ছে না।
There is no limitation.
No, my lord. And even then, there is no provision of injunction or in the filing of interlocutory application or any stay application.
You did not prefer any appeal from that order. There is an appellate provision.
No, my lord.
Yes, 147 is there.
147, not 140, relating to 142, relating to 148 to 2. Not related. Otherwise, I will used to go.
I will call for that whatever they have done. Where is your proceedings?
Yes.
Who is appearing for the state in this matter?
Who has passed this order?
That order is different. Who is appearing for the state? He has filed an application under 148. I'll call for the records.
Yes.
Entire records 148.
Yes.
Yes.
Was passed directing the society to admit a person as a member of this property.
By you.
It's different, Sumail.
Please wait, sir. We made submission, sir. You have been arguing that I have been practicing 30 years, sir. Sir, we have also been here for similar period, sir.
No,
so, sir, do not make these submissions, sir. Please do not make these submissions in court. Yes.
After they were not implementing that order. One application under 140 was filed for execution of the judicial order, directing them to induct him as a member of the society.
Yes.
This time this society preferred an application for review of my initial order.
Correct.
Of admission. That is under 148(2).
What are the grounds of review?
Your Lordship, I have to check what was the.
What is your ground of review? What is the ground for review?
Hold a moment. But we have not checked.
What is your ground for review? Tell me.
Hold a moment. Review application. My lord, we have not filed this review application because it has already been sent to the register revision case. That's why, my lord, we have not filed the revision application. We have said, but
the order which is annexed to their petition, Your Lordship, they are saying they have not filed a review application.
No.
My lord, he is simply trying to confuse, my lord.
What he was trying to say is, when 142 application was being entertained by us, at that time he filed a review application to delay the entire matter. Then,
where is the review?
My lord, comes to page 186 of his writ petition, my lord. That was what I was willing to point you out, my lord. My lord, after 64(3) was disposed of in my favor, I filed an application under 142, seeking the implementation of the order. And they filed an application under 148(2), seeking the review of the order passed in 64(3).
Yes, because there is
both these two applications were conjointly disposed of by an order dated 4th April 2024, which my lord will find at page 186 of the writ petition. Now he is seeking a revision of the review order.
What happened?
My lord, what kind of submission is he trying to make, my lord? By shouting, is he trying to suppress us?
No, let him say.
Where is that order?
My lord, page 186 of the writ petition, my lord.
Yes,
comes to page 186, and my lord kindly peruses the minutes
on the
together.
Single day.
Both were heard out analogously, my lord. Both were disposed of by one single conjoint order.
By where is that order?
My lord, page 186 of the writ petition.
Yes.
And my lord,
under 142. This is under 142.
No, my lord.
for execution.
No, within that.
My lord, within that.
Who was under 148, section 2, Your Lordship.
My lord, comes to the operative portion and 195.
Yes. He also sought for hearing of petition 148(2) of the such and such.
Yes, my lord.
Your Lordship. And we have clearly observed that this is a directory practice applied by him to disobey the orders of the registrar. Page 195 is already called.
30 years of practice.
No, this order records. That it shall be heard considering
analogous.
What happened to that?
And it was disposed of.
Where?
Comes to page 195.
195. That's the operative portion of the order, my lord.
No, this 148 proceedings, how could you hear?
Your Lordship, there is a provision that the registrar who has passed the order has the right to hear out the proceedings or review its own order if an application is made. Your Lordship, kindly see 148(2). 148(2).
From that order, he has proceeded before the,
Revision. Allegedly filed a revision.
where is the revision?
My lord, we have not been privy to that application.
Page 80 and 95.
My lord, we have not received a formal service of that application either from the authorities or
No,
from
no,
him.
no,
Page 80 and 95. Page
80 and 95.
Slowly, sir,
We
slowly.
have annexed the party copy.
Page 80.
Page 80, my lord.
Yes, where is the
Forwarding
receipt?
letter and thereafter the application is enclosed.
No, no, where is the application receipt?
Application. No, no,
It was not served upon me.
page
my lord.
81, my lord. Page 81. Page 81, page 96.
It's an application.
My lord, sir. Along with party copy, sir.
Yes, madam, kindly take instructions on this document, madam. Kindly take instructions on the application. What is effect of this? If you have not decided the same, the court will decide it.
My lord, kindly.
I'll take up this document so far as I'll call for these records and hear it.
My lord, only kindly appreciates one
This is
thing.
my lord.
There was no
Yes.
formal service
My
of this
lord, what
application
happened?
upon me, my lord.
What happened? State cannot interfere in the democratic institution to, of the policy section 2, subsection 2. Kindly see for a moment. Section 2, subsection 2, state cannot interfere in the administration of the society. And kindly
You are having a board.
Huh?
You are having a board.
Yes,
Yes.
yes, yes.
Democratic board is there. My lord, section 2, kindly sorry for a moment. Section 2, subsection 2, it will suffice. State cannot interfere.
What is your
A
context
person
here?
who has no qualification and at the age of 49, I have to admit, even then taking interview, that he is not qualified.
What is the function? What do you discharge?
To collect fee from the market, with parking fees, my lord.
Parking fees.
Parking fees.
Parking fees.
This
What
type of-
qualification do you have
Yes.
for the persons who collect fees?
Qualification, my lord, no, at least no qualification as such, no qualification is there. But facts
Then
remain.
why are you submitting that a person
I
does
am
not have
coming. I am
qualification?
experienced. Page 49. Kindly see, in the age of 49, a person coming taking the advantage of the administrative authority. I will show how the administrative passes this order. Kindly let me proceed. Administrative, they
You
have
are
the
proceeding. What more you are doing? You are proceeding
my
in the
lord.
matter.
My lord, kindly see, this is a cooperative society formed by the unemployed persons for their livelihood. All from 1980, all on a sudden, by some relation, he has filed an application at the age of 49, doing service elsewhere, and that he was not unemployed all the life.
You're right.
My lord, I will be very candid here, my lord. He's an unemployed person. Came across, my lord,
At the age of
some
49.
information. And he wanted to seek an employment with the society. He's an eligible candidate. His candidature was rejected summarily. And my lord, thereafter, there was a proceedings, my lord, whatever is on record before your lordship. He filed an application under section 64(3), which was disposed of in his favor. Then the society, notwithstanding the same, did not give him the membership. Then he filed an application under 142 seeking the
What is your
implementation
right
of
to get the membership?
Yes.
that's my lord,
What is your
seeking
right to
an
get the
employment,
membership?
my lord, the society.
What is your right to get the membership?
My lord, similarly, my lord, I cannot be obstructed just like that, my lord. Even if I am eligible, my lord, the act says the eligibility criterion is pretty much envisaged in the act, my lord.
Understand what is his right to get membership also? Why are you insisting that he should get a membership?
Yes, my lord.
I have to pass it. If I pass an order, there is a criteria for becoming a member of a cooperative society. It's not like a private limited company that.
So can you interfere? Which member they will take and which member they will not take?
That possibly
Show me.
allows.
Show me. Yes.
Bylaws. My lord, their bylaws also do not.
Section 60.
Especially when there is a board.
In that case, we have to interfere. Section 64.
Especially when there is a board. Yes. Appeal within 60 days.
Apply to the cooperative society. or membership of the cooperative.
Where is his rejection? Where is the order of rejection?
My lord, will find that from the earlier writ petition, my lord.
Yes, yes, everything is here.
My lord, I'm pointing that out to you.
Yes.
My lord, his initial order of rejection is at page number 57, internal page number 57 of the earlier writ petition, my lord. It's in Bengali.
You have difficulty to read Bengali?
My lord, I have not annexed a translated English copy of it, my lord.
Page number
57, my lord.
of the WP 17218.
218, yes, my lord.
No, it is not there. 57.
Rejection order.
My lord, will find it, my lord. That is,
No, 57 is something else.
my lord, the earlier writ petition, my lord. My lord will then turn to
Where is
page,
the order of rejection?
Yes,
Page 36.
my lord, initially what happened?
Where is your order of
Page
rejection?
31.
31 later on page 36.
With this petition?
Thereafter, my lord, yes, yes.
Initially rejected, তারপরে called.
my lord, it is at,
After proper interview.
my lord will find it as annexure P7 of the earlier writ petition, my lord. My lord, here it is.
Then rejection, where is rejection?
Rejection is called for interview.
Final rejection.
P7, my lord,
After interview.
P7.
After interview.
Order of,
P6 read the defense. Type document.
यही तो है बेंगोली डॉक्यूमेंट. My lord, this document is in Bengali, my lord. That is that.
I
my
can
lord-
read that. It is difficulty for you to read that.
No, my lord, may I read that?
Yes, yes.
29
সমিতির অর্থ সংকট ও উক্ত সাক্ষাৎকারের ভিত্তিতে ঠিক সৌগত দত্তের আবেদন মঞ্জুর করা গেল না.
Yes, my lord.
Financial difficulties there. What the registrar had to say on this?
My lord will find registrar's first order, my lord, at the very next page of this
এবং লিখিত
document.
উত্তর মূল্যায়নের পর after examining your written examination, the results, the
Yes.
document, your papers were examined.
My lord, only, my lord,
Where is the registrar's order?
my lord, right at the next page, my lord, proceedings of hearing under section 64(3).
Interview sheet annexed at page 32.
My lord, interview page also annexed, page 32.
My lord will find the order of 2nd February 2024.
They are not entitled to find out whether he is eligible or not.
Yes, according to bylaw also. উপযুক্ত ব্যক্তিকে দেওয়া হবে। উপযুক্ত।
Reason for rejection is improper.
You ought to have directed him to reconsider his case at the most. How can you direct him to accept it? Include his name. You have decided that he will be included.
The act has to empower us to.
I can do this. If you agree, both of you, I can direct him to reconsider your case at the most.
Subject to my lord examination.
Correct.
Because,
Correct.
yes, subject to
Subject to examination, if you are agreeable. This order goes. I will set aside this order.
Page 35.
If his bylaws, you appear as per the bylaws. If he is other found eligible as per the bylaws, he will accept it.
Declaration.
Show me your bylaws. Show me your bylaws.
And then, my lord, there will be another round of litigation.
Nothing. The litigation will come to an end.
First job from.
Litigation will now come to an end. Because if you are not eligible, you will not succeed.
My lord, the fact is,
Show me, show me.
He's not been able to
Yeah.
finance his litigation.
Where is your bylaw?
সেটা বলেছি। Yes, my lord.
Where is your bylaw?
My lord, I am not.
এটা
উপযুক্ত ব্যক্তিকে নেওয়া হবে। Yes.
My lord,
My lord,
how,
before that,
how are they deciding that whether I am upajukta or not?
yes, that's why
That is the
examination was
employer's
taken.
discretion. That is the
And that's why
employer's.
examination was also
What's
taken.
the provision of the Cooperative Societies Act? Who can apply for membership?
Correct. Still then.
My lord, kindly see the page. Kindly say the third para, this page. Kindly see.
Tomorrow, if he suffers financial irregular defalcation at his hands, what will happen? These collection, he's a collection agent.
All others are also collecting the money from the parking.
সাধারণত
My lord, what is their difficulty in admitting a member?
Certainly not. He has a choice or not to admit.
My lord, kindly seize the
Well, you file your affidavits. You file your affidavits.
My lord, may I file the affidavit?
File your affidavits in this matter.
My lord, may I file the
The
affidavit?
interim order already
My
there.
lord,
Having heard the learned
My lord, we'll have to argue out afresh.
probably 6 June, 6 June, stay order is going, its period is 6 June. Until disposal.
Yes, until disposal. I'll make it time bound.
No.
May I just indicate one thing, my lord, kindly appreciates it is just prolonging the agony of my client. My lord.
I will not take up. Unnecessarily wasted the time. I thought that this matter could be disposed of earlier. Yes, President.
My lord, sorry to disturb your court regarding my, because I wanted to say something else from my side.
Yes. Your affidavit.
Yes.
My lord, I appear for the respondents number 13 and 14.
Yes. What steps have you taken for the election, sir? You are Mr. Mojindar, you are leading him? No. Very well. Yes, you are there. Yes. Mr. Bose, you are leading him.
Yes, my lord. No, my lord. He is the election commission, if I am not wrong. I am for the respondent number 13 and 14.
Bandopadhyay is there, my lord, for
Continue, tell me.
Yes. My lord,
Mr. Bandopadhyay has said he is independent. He is not joining any sides.
No.
So you tell me what steps have you taken?
My lord will take the affidavit.
You tell me.
Yes.
You have prepared the affidavit. You want me to go through the entire affidavit?
My lord will kindly take up page 105.
Yes, what steps have you taken?
Page 105 is the publication of notice in the newspaper, my lord, which speaks of that we have been publishing the draft voter list. It is a publication of 8th of March. On 6th of March, we published the draft voter list. And we asked the chairman of the nominated board, my lord, to make sure that it is circulated in the notice board of the organization. On 8th, we made a paper publication saying that we have already published the draft voter list on 6th. And if anybody is interested to raise any objection from 7th to 12th, they are free to come
Any
up.
objection you received?
No. And Millard will kindly.
All members are voters.
No. Millard, that I do not know. My instruction is my instruction is that whoever is an employee in the CSC or whoever is an employee of the cooperative society is a member. So accordingly, my lord, we had written a letter to CSC on 11th of March saying that kindly vet the draft voter list by 13th of March. Because ultimately, my lord, if CSC does not give me the voter list, give me the list of the employees, we would not know if somebody has resigned, died or retired. So CSC did not give any reply. My lord, will kindly take up page.
Who is appearing for CSC? You are appearing for CSC.
But I am, my lord. I am, my lord, appearing for the CSC.
You did not submit.
My lord, kindly sees, I will go by the submission made by Mr. Nag. They sent me a letter on 11.
Since he is not audible, not all regular employees are members of Cooperative Society. Whoever is a member, or no superannuation.
Employees' names and whether they are employees or not, and whether they within
appearing for
more than thousands. Well,
solution when the officer subject to correction, you get no grievance. Mr. Mitra is appearing for the chairman, Mr. Mojumdar is appearing for
Society. Respondent number 10.
But my lord, so far as I have been informed that we are communicating with the chairman of the society. We are not communicating with anybody else because there is a secretary, but the secretary has retired. So, and all our direction is
you did not make available the documents.
All they are not. All regular employees are members.
Why do you want to delay the election process?
Millard will kindly take up page 105.
This court will not take things very easily, sir.
Kindly take up page 105A1.
If you have not discharged your functions, then you should not be there at all. Then you should be disbanded.
Page 105A.
Yes.
Millard, page 105A. Millard, see the last line. This is the notice which was published in the newspaper. Let's see the last line.
The date of publication of the voter list is over.
Yes.
Did you publish the voter list?
No. What we did was.
No, did you publish the voter list? Yes.
On 6th of March, we wrote a letter to the chairman. We published this notice. And in the notice, the last line says that the chairman will display it in the organization's notice. And thereafter,
no, it was your obligation to publish the voter list.
We published.
Where is that voter list? Where is that voter list? Why did you not annex it in the petition, in your affidavit?
Humongous 5,308 members voter list, which is quite huge. That is
most
you
published
submitted orally that no steps have been taken this far.
No,
it was not possible to complete it.
No, we published it. I never said, Millard, that.
And that is the reason why this court was compelled to pass this order.
No. We say, Millard, our submission was that we have done every possible thing and we will show it in the affidavit. Millard, we did not say that we did not comply with the directions.
Have you published the final voter list?
Final, that is separate.
Where is that?
This is, Millard,
no, where is the statement here that you have final published the voter list? Where is the statement?
8 on.
Paragraph 8 onwards.
Yes.
Thereafter, the deponent, Vide memo number such and such, dated 10th February 2025, directed the said cooperative society to submit the members list as well as the delimitation list. Ultimately, on 24th February 2025, the member list was submitted by the said cooperative society without the delimitation list. The assistant returning officer on 5th of March 2025 once again wrote to the said cooperative society asking it to submit the constituency-wise delimitation of voters by 6th of March 2025. However, the delimitation details was not provided by the nominated board on 6th of March 2025. Thereafter, the assistant returning officer proceeded to hold the delegate election as scheduled for 17th April 2025 and published the draft voter list on 6th of March 2025. The ARO wrote to the chairman of the nominated board to put up the notice of the draft voter list along with the draft voter list on the notice board of the said cooperative society. The said a notice to that effect was also published in Sangbad Pratidin on 8th of March 2025, expressly declaring the dates of submission of claims and objections to be from 7th March 2025 to 12th March 2025. It was also mentioned that the final voter list shall be published on 17th March 2025. Meanwhile, on 11th March 2025, the assistant returning officer wrote to the CESC Limited asking them to verify the draft voter list of 5,350 members. However, neither the CESC Limited nor any member raised any objections to the draft voter list within time. Hence, the final voter list along with the constituency-wise delimitation of voters was published on 17th March 2025 as the delimitation list was received from the nominated board on the self-same date. So we got the delimitation list on 17th March, we published it on 17th March.
And your last date was 17th March.
17th March was the date of the publication of final list. This
Correct.
Not last.
Thereafter.
The assistant returning officer wrote to the chairman of the nominated board to put up the notice of publication of final voter list and delimitation list on the notice board of the state cooperative society. I can also show it from the documents. My point is, I cannot physically put up any notice in the organization's notice board. That is the reason there is a nominated board. If not nominated board, an outgoing board.
No,
if
today, the special officer is no longer there.
No.
Today the nominated board is there.
Milord will kindly take.
Who is representing the nominated board?
Milord, according to us, Milord, the chairman is the executive. We have not communicated with anybody else.
Chairman is the executive of the nominated board.
Yes. Why so? Because the secretary has retired.
Right.
No, I did not know that he is appearing. I have sent it to the chairman.
So after 17th,
yes.
After 17th is distribution, 21st, distribution and submission of nomination papers. That has been done. Distribution and nomination, distribution and submission of nomination papers.
Yes. Nomination. They have people have. Milord will kindly take up paragraph.
Scrutiny of nomination papers complete.
Milord will kindly see paragraph 11 and
12. Wait. Let us go.
11, 12 will gives the answer.
Withdrawal date is over.
Yes.
Final list of valid candidates is there. Milord, then election of members delegates is fixed on 17th April.
Milord will kindly see paragraph.
There will be no voting in 5 constituencies because there is no nomination.
No.
There will be polling in respect of 10 constituencies.
Milord, if only Mr. Mujumdar can speak in the mic, Milord. I'm sorry, Milord.
Uncontested 12 there will be vote. I do not know.
15 constituencies uncontested.
Milord will kindly take up paragraph 12 once.
Yes.
Because the regular employee or not will be voting.
So there is no difficulty then.
Milord, we did not say that. Milord, our point was very clear that we have difficulty in 2 points. First, if Milord asks us that how did we put it up on the notice board, we will say we do not know.
Oh, it was not put up, my lord. These are my submissions. I'm sorry, my lord, to intervene, my lord. These were not put up.
Because I, as a election commission, cannot travel in the premises of the CESC. That is not my job.
So what do you suggest by that?
No, my point is the chair. If there is any allegation, my lord, my point is my officers cannot be held liable. If there is any difficulty, it is the chairman who has to answer.
You cannot absolve yourself of the responsibility.
But my lord, the
and
chairman
that is
also,
why it is there on record.
My lord, we have.
My lord, I hope I am audible, my lord. My lord, I hope I am audible, my lord.
Oh,
today, paragraph 12. Paragraph 12.
My lord, I hope I am audible.
That elections are to be held only for 12. Uncontested is, in terms of the election process held, 15 delegates have been elected uncontested, and election shall be held for 12 delegates only.
Yes.
So let it continue. There is no difficulty. Yes, sir.
My lord,
is before courtroom number 3, my lord, he has instructed me to take a passover, but only one thing, my lord,
You ought to have indicated at the very outset.
it's my
I thought
my lord, may I say this, my lord?
both.
No.
Everyone
My
wanted
lord,
that.
may I say this, my lord?
No. Our point was, my lord, I was apprehensive that my officers would be hauled up for something which my officers cannot do.
The election cannot be postponed in this fashion, sir. Yes, I will. I will hear Mr. Mujumdar. I'll fix it, not today.
My lord,
The election, 17th. Tomorrow you are there?
my lord, may I say this, my lord?
No, Mr. Mitro, you difficulty you see. Today in the afternoon, that matter is there.
My lord, may
Just a minute. Group 4 matters are there from 2. If it is not taken up now,
But
at the most I can fix it tomorrow. Not be here tomorrow. Just you have supplied, everything has been complied with. 12 have already been
no,
elected.
my lord, no, it has not been. My lord, I do not know, my lord, whether I am audible to the court or not, my lord.
Yes, come up with 2 names I can appoint. I don't want to.
This list is also with me. This is
You are appearing for society. And Mr. Bose is appearing for? You are the
My
chair.
lord, I am appearing for CSC, my lord. I don't know.
Nominated
My lord,
board.
I do not know whether I am properly audible or not. I wanted to.
Service on them.
Yes.
They were not served initially.
That is.
So affidavit, tomorrow I'll keep it. No, I have faith in the chairman also. There is no difficulty.
My lord, I do not know, my lord, whether I am properly audible or not, my lord. I was trying to point out only one thing before your lordships.
No, do not discuss it. You can write down and hand over. I can. But you see, someone of a stature. Yes.
না I'm sure শুনতে পাচ্ছি না অসিত কি বললো
কাগজ দাও আমাকে I want to discuss the name because at the end of the day these are senior advocates. ছোট্ট একটা কাগজ দাও Mr. Mojumdar, you just write down if you ওখানে ওকে একটা কাগজ দাও আমি আর লিখে দিচ্ছি ওকে ওটা দাও না ওকে দাও
But my lord, our rules contemplates appointment of special officer from within the government. If my lord wants to see that.
If he agrees, attend and come back. Agree.
My lord,
with a junior, he cannot go. Just.
My lord, I do not know, my lord, whether your lordships are being able to hear me out, my lord, or not. But my lord, I had only one point to make before this honorable court. My lord, I do not know, my lord, whether I am properly audible or not.
Yes.
Only one thing on fact.
Tomorrow. I'll fix it tomorrow.
My lord, only one factual discrepancy was there on all the submissions made before your lordships, and one material fact has not been brought to your lordship's notice. My lord, the notice was not published in the board.
If you are agreeable with the name, please don't discuss the name. No, you can discuss the name with all of them. With all of them. Yes, privately, but I don't want the name to come out. So ultimately, someone expresses any reservation.
I don't know what's happening, whether I'm audible or not.
Government.
Don't name it. Don't. You can. You are not involved in.
We cannot give a.
You are not involved in this.
Because in generally, my lord, we have to oppose.
You let him take instructions. He can't say. His senior is there. Just intimate him tomorrow. Affidavit filed in court on behalf of the Yes, Mr. Nag, hand over.
I have already given it to the chairman. I will give a.
Or the learned advocates appearing for the respective parties. Mr. Abhijit Mitra, learned senior advocate, appears on behalf of the added respondents. No, chairman.
Chairman of the nominated board.
Chairman of the respondent number 12. No, chair, not the society. You are the chairman of the board.
Lord, the society is now represented and controlled by
The
a
chairman of the
nominated board.
respondent. Appears on behalf of the chairman of the respondent number 12. Full stop affidavit. Report in the form of affidavit filed on behalf of the respondent numbers 4 to 9 is taken on record. Full stop. Since Mr. Mojumdar, learned senior advocate representing the petitioner, is not available, let this matter stand adjourned. No. On the prayer of the petitioner, let this matter stand adjourned and appear under the same heading tomorrow. Top. 10:30 means first matter. First or second matter, whichever it is. It will be there. After the to be mentioned matters, it will be there.
Let it be the first matter.
Who are you? Yes, he is there.
My lord, I do not know, my lord, whether I'm audible or not. I was trying to make this submission, my lord.
Mr. Bose is already, I've heard him. Tomorrow.
No, my lord. I was trying to make an submission before your lordship. I do not know whether I'm properly audible to the court or not, my lord. I have been telling this, trying to tell this.
Tomorrow, Mr. Bose, tomorrow.
Very well, my lord. Let it be the first item then, my lord, kindly.
Call the list.
Very well, my lord.
Pleasure. Lord, the affidavit kept on record is...
Yeah, I've recorded that.
Public.
At the top, not. Normal আছে. কালকে ডেট দেওয়া আছে। তারপরে contempt.
For the petitioner, Your Lordship.
After the contempt, it will appear tomorrow. After the contempt matter. This is one contempt matter. After that, 10:35.
I'm for the petitioner, Your Lordship. Your Lordship, this is a housing society, Your Lordship.
This is a cooperative matter, madam.
Yes,
Not
Your
group 4.
Your Lordship.
Yeah.
Your Lordship, Anantadev Cooperative Housing Society Limited has 8 members admittedly. 6 are the petitioners and the respondent number 7 and 8. The society was allotted a plot of land in Salt Lake, Your Lordship. Sanction plan was granted. Your Lordship, a 4-story building wherein 8 flats would be there. Each member would get 1 flat. Your Lordship, thereafter, Your Lordship, as per section 89(1)(e), Your Lordship, pursuant to a newspaper publication, a development agreement was entered into with a developer, Rama Construction. Your Lordship would kindly take the development agreement, Your Lordship, page 227, Your Lordship. Your Lordship, I want to show something from Your Lordship. Actually, there are 2 development agreements. I want to show something, Your Lordship. I will not take much time. Just I'll come to the exact page. Your Lordship, volume 2, page 227. Your Lordship, the first development agreement, Your Lordship, is dated 7th October 2014.
Yes.
And Your Lordship, if Your Lordship straight away comes to page 238, Your Lordship.
238.
Your Lordship, volume 2. Your Lordship will find that Your Lordship, payment schedule. And Your Lordship, here the total estimated cost of construction is shown as 1,58,40,000, Your Lordship. Page 238, Your Lordship.
What do you want today, madam?
Your Lordship, here I am challenging the re-audit report, Your Lordship. But Your Lordship, Your Lordship. Your Lordship.
Sir, kindly wait, sir.
Yes. Your Lordship.
A member of the bar is making submissions. Let me hear her. I'll come back to you.
Your Lordship. Here, Your Lordship.
You are challenging the audit report.
Re-audit report, Your Lordship.
Re-audit report.
Your Lordship.
What is the scope to challenge this?
Your Lordship, I'll come. Your Lordship, twofold. Your Lordship, re-audit report is not in accordance with law and it is not in terms of the direction passed by this Honorable Court, Justice Sinha's order, directing that all parties should be heard. Your Lordship, re-audit is directed as per section 97 only when major discrepancy is found in the audit report. Here, the re-audit and the audit report is same. And Your Lordship, re-audit means fresh audit as per section 97. I will place it one by one. Your Lordship, I just wanted to give a background.
That certainly you would. It is
Your Lordship.
to group 4. So it's very clear on
Your Lordship, I have, Your Lordship, to my ability, I have prepared, Your Lordship. Your Lordship would just give me patient hearing. Your Lordship, twofold argument. One is on the fact to understand the background, and then Your Lordship, I will straight away come on the challenge to the re-audit, Your Lordship. Your Lordship, so Your Lordship, I was just placing the first development agreement. Your Lordship, as per this development agreement, the total consideration is 1,58,40,000. And Your Lordship would find that subsequently, Your Lordship, the rate is provided, foundation, per slab casting. So Your Lordship, it is as per the rate.
All these fact matters which are within the realm of the private contract, can it be brought within the article?
No, Your Lordship, I am only on the re-audit. Your Lordship knows that re-audit would involve accounts. And Your Lordship, for that purpose, I am referring to
The
this.
order passed by this court directing audit at the first.
Re-audit, Your Lordship.
Re-audit, that
Yes,
is
Your
page
Lordship.
397.
Yes, Your Lordship. Page 397, 398. If Your Lordship wants, Your Lordship, I can start from the re-audit report also.
Audit. So you are aggrieved by the this is the re-audit.
Your Lordship, I am aggrieved by the re-audit report. Your Lordship, re-audit does not comply with the twofold condition in this order. First condition is, Your Lordship, that it should be done in accordance with law. And the second condition is that hearing should be given to all parties. Both the conditions are not satisfied. Your Lordship, if Your Lordship, only two development agreements, single page I want to show from the two development agreement, then Your Lordship, I'll come to the rate.
Not given opportunity of hearing.
No, Your Lordship, and post facto I have been offered hearing. And Your Lordship, it has been, Your Lordship, this has happened, this development has taken place after the rate. So Your Lordship, it is not annexed, but I will hand over, Your Lordship. Your Lordship,
Where is the audit report?
Your Lordship, at page 476 to page 481. Your Lordship, may I place it straight away, Your Lordship?
Entire audit report you want to place before this
Page,
court?
Your Lordship, because every paragraph I can show that respondent number 7 and 8 gave information to the administrator, and that was verbatim recorded in the audit report. I was not given an opportunity of.
Who are you, madam?
I am petitioner number 1 to 6. We are the members of, admittedly, we are 6 out of the 8 members of the cooperative society. Your Lordship, as per this agreement which I was showing, I was supposed to pay 19.8 lakhs. Each of the members have paid over 26 lakhs. Still, they are being called defaulters. Your Lordship, a board was constituted wherein petitioners were office bearers. They were removed because, Your Lordship, the first audit report called them defaulters. That audit report being majorly discrepant, re-audit was directed. Re-audit raised several queries, which is at page 311, Your Lordship. Your Lordship, cash transaction below above 1,000 rupees cannot be allowed. Here, more than 6,40,000 was in cash. Your Lordship, certain payment by the developers in the account of the society was shown as contribution of other two members, respondent number 7 and 8. Your Lordship, the second developer who's appointed is the brother of the respondent number 8 without any newspaper publication.
Conducted this re-audit?
Your Lordship, the respondent number.
Officers of that directorate, auditors of that directorate.
Yes, Your Lordship.
This is a statutory audit. And they are in the panel of this only one person.
They are officers of the directorate. They are full-time employees, the auditors.
They are whole-time employees.
Your Lordship,
Directorate of cooperative audit. The directorate of cooperative audit within the cooperative department.
I see.
Your Lordship, the director appoints the re-audit team. Your Lordship, now Your Lordship.
Director is there.
Director of cooperative audit.
And the chartered accountants are all employees of the
Your Lordship.
Cooperative.
Your Lordship. And Your Lordship, here, Your Lordship.
They registered. Yes, director. Yes.
Your Lordship, the short point here is that, Your Lordship, the re-audit report records that there was no escalation. So, Your Lordship, if there is no escalation, I was liable to pay 19.8 lakh. I have paid more than 26 lakh admittedly. But still, Your Lordship, in the re-audit report accounts, they have certified the same all accounts. They have again called me defaulter. And Your Lordship, again, an arbitration has been started by the contractor where he is relying on this audit report. Your re-audit report, I have annexed that by way of a can, Your Lordship.
No wonder you have come before this court challenging this.
Your Lordship.
So this is being used as an evidence in that particular.
Your Lordship, against me. And Your Lordship, on this basis, Your Lordship, the board is not there and administrator is there since 2019. I cannot come in the board because I am a defaulter. A defaulter cannot be a member of the board. And Your Lordship, secondly, I am having to deal with this arbitration.
Two pronged attacks. One, that you are a defaulter and therefore you stand out. And secondly, on the audit, you are being shown as a defaulter despite the fact, as I have understood, original agreement The consideration was 19 lakhs, you have paid 26 lakhs, and the audit saying that there is no escalation.
Still, Your Lordship, they are certifying the same account as true and correct. And Your Lordship, this account is the basis for
very glossy, your arguments.
Your Lordship, I have everything, Your Lordship, page by page. Your Lordship, may I place it my way?
Show me.
Your Lordship.
Procedural irregularity in holding the audit.
Your Lordship. So, Your Lordship, I will straight away place the re-audit report, starts at page 476.
The entire report you need not place.
Your Lordship, relevant, I will show Your Lordship, relevant point by point. Your Lordship, here, Your Lordship, under the heading preliminary at page 476.
Can I go into this audit?
Your Lordship, prima facie, ex facie, I will show that I have not been heard. Their admission, I have made a written complaint, which is on record. And Your Lordship, they are not saying that I have been heard. Thereafter,
and I will get to know from them directly. They will tell me either you have been heard or you have not been heard.
Because they are taking an inconsistent stand on the one after the, Your Lordship, they are offering me hearing post facto hearing.
That is not permissible. Very
On the other hand, they are saying that they have already given me hearing. Twofold, Your Lordship. That's why I want to show Your Lordship this letter. Your Lordship, I had also given a notice under Contempt of Court Act. After that, Your Lordship, I received these two letters. In the first letter, Your Lordship, the director says, give them hearing, Your Lordship. And the second letter, Your Lordship, the person who conducted audit is saying you were patiently heard, but I will still give you hearing, but re-audit report remains. So, Your Lordship, this is the problem.
Were they heard?
We were not heard, Your Lordship. The re-audit report shows that I was not heard.
Who is representing the director? Was they heard?
One example, Your Lordship, may I give?
Nobody knows whether they heard or not.
May I give one example, Your Lordship?
They ascertain this, Mr. Nayak. Ascertain this. If they have not been heard, the court directed them to heard this. This report cannot be considered at all.
My instruction is this: they were given opportunity.
Your Lordship, who is my learned representative?
Person concerned. Because notice of hearing is being served on 10th of January 2025.
Your Lordship, it's a WhatsApp message. One of the member received out of 6. Still, we appeared and gave a written representation.
Yes. No. High Court directed. High Court directed. You have accepted that order, Mr. Nayak. Now, once High Court directs, you accept that order. You cannot today say that order is contrary to law. So therefore, prima facie, you show me that they were heard. If you can't show me that they were heard, then difficulties are there. You understand. Then, because today High Court has passed an order. My coordinate bench, I have to uphold that order passed by my coordinate bench.
Your Lordship, may I just show one thing, Your Lordship? Your Lordship would kindly take page 478.
Challenge, Ashuna. Let them take madam. Let them take instructions.
Your Lordship, let there be a stay of this audit report, Your Lordship, so that they don't use it in arbitration, Your Lordship.
The
No,
Just-
and justice John Dina's order was complied with, everybody was called, everybody is summoned, they did not dispute
not
something
stay.
else. Unfortunately, the instruction is not there. Unfortunately, the
On
instruction is
the
not
come
there.
up on the
The fact is entirely different.
yes.
So it will appear, my lord.
I have accommodated you tomorrow.
Tomorrow.
Because you are not there. So I have proposed one. Since the discussion was there, not necessary. But do not discuss the name if you do not are not agreeable to.
No. We are agreeable. We are agreeable. It has fallen from my lord and
No, Arif, Mr. Mojumdar.
and what the name what has fallen from.
And I want one more indication.
Most appropriate
I have
person.
only one more indication. One more indication. I have said that junior of his choice has to be
Yes,
there.
yes.
Because otherwise, someone else is appointed.
No, man. We are absolutely.
I appoint you. You have to have a say on who the junior will be.
Yes.
Person who is close will be in a position to better interact. But whether he is free or not, ascertain. Whether he is free, he's not free.
He is not there.
Oh. Write down and hand over in slips. Don't discuss the name.
Yes.
Discuss with all the parties and Mr. Mitro and hand over. Don't, because ultimately if it's not accepted, difficulties, embarrassment for everyone.
But date will not be a factor because our initial prayer remains. Because
Now only 12. 15 has only 12. Uncontested 15 is over. Only 12 we are concerned. Affidavit has been filed by them.
I will place from the affidavit what has actually happened.
Yes. We'll consider that.
Because I think your lordship may stick to that earlier name. Because if I am able to convince that, whatever, may I just.
But you also discuss.
Will your lordship take up this matter after your lordship comes?
No. Today, one anti-dumping matter is there.
Very good. No. There is no
for urgent matters also, I am not in a position to touch.
Then tomorrow we'll come.
Tomorrow is the best thing.
Tomorrow.
No. কালকেও ছিল না? It's you're there in this matter. Proclamation of sale notice is seeking cancellation. Petitioner. Pramodip Chakraborty, you know him? None appears for he's not there. By that time, sale will be over. Same order. I'm not dismissing it, sir. I will adjourn it. No, you see, sir, difficulty is if I dismiss it. Although I've dismissed many matters, but I remember, you remember Mr. Subroto Ganguly sitting in room number 7, bar session room number 7. Subroto, I used to always tell me that dismissing a matter is like punishing that person because he will have to file the petition, spend additional court fees from his pocket. He said, I have to pay once again, I have to come up once again and get it restored. Adjourn it. Now I'll tell my client it was not there, what can be done? To restore it's more difficult. Sad, he died early, Mr. Ganguly died early.
Lordship, I beg to appear. I beg to appear on behalf of the petitioner, Lordship. Mr. Karthik Bhattacharya is appearing. He is engaged in court number 35. I'm just praying for short passover.
I'll adjourn it on another date, madam.
Lordship,
Next monthly list.
Lordship, just short passover, Lordship. He's engaged in 35. He's on the way.
You move the matter, madam. Nobody is stopping you. You move the matter. Tell me what is the matter.
Lordship,
tell me what is the matter.
The matter is, Lordship, the petitioner was appointed a contractual worker in a Shipur Cooperative Bank, Lordship. After that, Lordship, suddenly bank stopped him to restrain him to come to the Lordship.
Service matter in connection with the cooperative.
Yes,
cooperative bank.
Yes, Lordship.
Very well. Who is appearing for the cooperative society?
I appear for this respondent.
Yes.
So stop to pay, and suddenly the bank stopped to pay the remuneration from the month of January 2021. Lordship.
2021.
Yes, Lordship. Thereafter,
he's still going to the bank every day.
No, Lordship. After that, he requested the bank to absorb again and to review the matter, consider the matter.
Where is his data? Where is his letter of appointments?
Date of appointment, Lordship.
Letter of appointment first. Show me.
Yes, Lordship. The date of appointment is, Lordship, on 10th January 2019. Lordship. And the appointment letter issued, Lordship, on 1st January 2019. The page, Lordship, kindly see page number 7, Lordship.
7?
Yes,
Only
Lordship.
7 or 7?
7, only 7, Lordship, in the petition.
Yes.
Lordship, para 10, Lordship. May I read, Lordship?
Yes.
So, Lordship, the chairman of the said bank, after satisfaction of the interview given by the petitioner, issued appointment letter dated 1st January 2019 in favor of the petitioner and directing him to join with 10th January 2019 on a contract basis for a period of 2 years, Lordship.
So his period came to an end in 2020.
Lordship, the matter, Lordship, what happened, Lordship? At that point of time, Lordship, 2 were also appointed, Lordship, but they were considered as a permanent employee of the bank, Lordship. Lordship, I'm just coming to the Lordship.
The concerned respondent to the bank. They are not.
Lordship, kindly see, Lordship, page number 8, Lordship, para number 16, Lordship.
Yes.
Lordship, the aforesaid act on the part of the aforesaid act on the part of the bank authority is full of discrimination, as the bank authority in similar circumstances absorbed 2 colleagues of the petitioner on the self-same advertisement and on the self-same appointment letter as the permanent employee of the said bank, and from their date of joining they were paid an amount of 12,000 per month instead of 2,000, Lordship, as their consolidated allowance, and as such bank authority having played a discriminatory act by not absorb the petitioner as permanent employee in similar circumstances, Lordship. Lordship, Lordship, petitioner requested, Lordship, made a representation on 13 January 2022 for praying for the re-employment in the bank, Lordship. Lordship, Annexure P4, Lordship.
You are Miss Roy?
Yes, Lordship.
You are Miss Roy?
No, Miss, no, I am not. The advocate is.
Your name?
My name is Shomastri Datta.
Miss Dotto, you see, you are seeking absorption.
Yes, Lordship.
You are a contractual employee.
Yes, Lordship.
Now, whether the bank had any policy of absorbing these persons, I do not know. Ordinarily, however, madam, you ought to have considered Umay Devi 3's case.
Yes, Lordship.
State of Karnataka, 2006, 1 SCC, page 1, perhaps. Consider that, madam, and come. I'll direct the contractual employee. Contract came to an end. Correct. But you see, the cannot be permitted regularization, absorption. How? Law does not permit unless the bank has a policy.
Here the bank
Correct. So I have to ascertain from the bank. The petitioner in effect seeks Nothing. If the bank comes and agrees, agrees. Otherwise, you have a Umadevi case, it matter comes to an end.
If Lordship covered Article 14, that if the person was
that is the reason why. That is the only thing. That is the other. Without Article 14, she does not stand a chance. She has come forward. Let a notice be served. Let us see what happens. Let the man come up and say this. They express their stand. They might. There are policies in some cases.
they have their own autonomy because they can decide.
Next. Madam, respondent number 6, Miss Dotto, respondent number 6 or 7. देखिए फाइलটা দাও আগেরটা দাও একবার no she was employed with respondent number 6, that is a statement. তাহলে দু জায়গাতেই madam, it should be 7 in both cases. 7 হবে, হ্যাঁ দু জায়গায় 6 বলেছি, দু জায়গায় 7 হবে. Employed with the respondent number 6.
Sorry, I mean,
It doesn't matter.
Yes.
Your junior is here.
Yes.
Yes.
But I am appearing on behalf of the petitioner, my lord. But in this case, my lord, case is, my lord, the violation of section 59.
Give your name, appearance. Give your appearance. Give your appearance.
My lord, the violation of section 59 of the Cooperative Societies Act, my lord. Violation of the section 59 of the Cooperative Societies Act, my lord.
Now I will not. Why shall I entertain this violation?
My lord,
What steps have you done? What steps have you taken?
Yes, my lord, I have taken, my lord.
Yes.
My lord, kindly see the my lord, from page 41, my lord. Page 41, several correspondence has been made, my lord. My lord, kindly see the series of correspondence.
Where was reminded?
Where is your requisition?
My lord, kindly see, my lord, everywhere it is written, my lord, there is a violation of section 59.
Who is the employer?
Employer, my lord, here, my lord, the sub-inspector of school.
Petitioner taken loan from you. Where is the employer? Which is the employer?
My lord, kindly see the declaration, my lord. Yes, my lord.
Petitioner is respondent number 13.
13, my lord. Declaration is page 33.
I don't understand, Mr. Roy, here in these matters. If you are not getting, question is, some security must be there. If you are not getting the payment, why are you waiting?
Salary security.
And if you took loan of the society, law is very clear that the employer should give a declaration.
Correct.
And he is under obligation to deduct it on
Now,
every
the
month.
moment the employer does not deduct, why are they waiting?
That's true. That's true.
Why are they waiting?
But they are without giving cases repeatedly.
No. Why are they waiting for him to retire?
My lord, he has not retired, my lord. Still in service.
2022, you have served notice.
No, my lord. He will retire at 2043.
No. You have served notice on 2022.
Yes, my lord. There.
What happened thereafter?
Before that, my lord, he had made some payments, my lord. That is why notice was not given.
From 22, what happened thereafter?
Thereafter, nothing has been payment.
Why did you not approach earlier? We are in 2025. 2 years have gone.
Yes, my lord. This is a cooperative society. If there is no board, my lord, after election, the board has come. Therefore, took the decision. Thereafter, the case is filed.
In the earlier case, my lord, there was he was retired. And in this particular case, there
He is not retired, my lord. He is still in service till 43, my lord.
In some of the cases, I find 50 lakhs, 60 lakhs.
Right.
There is no police case, nothing.
That's why, my lord, under section 59, subclause 2, there has been stipulated that 12% interest would be levied on the employer who has given the.
The present petition has been filed. The instant writ petition has been filed.
My lord, I am claiming for 1 day accommodation, my lord.
Not today.
My lord, I am appearing on behalf of the state, my lord.
Not today. Not today.
Also, next matter was same.
Mr. Sengupta, your interest has been protected in that matter. When I've read the order, your entire interest is protected. Why were you so anxious?
Same.
Yes. Next.
135 and 36, madam. 1135 and 1136.
Not today. Not today means not this week. Next. Dago.
37. My lord, I am appearing on the behalf of the petitioner, my lord.
Same point.
Same point, my lord. Is a one loan. He is also.
Who is appearing?
The first time it is.
Why have we not served?
Yeah, everybody has been served.
Affidavit of service filed in court is taken on record. The matter pertains to infraction of the
Yes.
1138.
Take for the petition.
It's very well. I'll take it. It's already 1:15. Next. On the next date. It'll be taken up, sir. But
117. Class officer. He's saying the dealing is ability. If we can take 117.
তাহলে ওই যে নামটা আছে না, তাহলে since an accommodation ওই মিস্টার নায়কের ওইটা কেটে 1137টা কেটে দিয়ে সেখানে since an accommodation has been sought for same direction only that you are in the other matter you are there. Let's take it up.
Because since he has told me, so it's my.
দুটোর সময় আছে অনেকগুলো মামলা হবে। হ্যাঁ আজকে চলে যেতে হবে, তো আসতে হবে। দরদাস অরিজিনাল সাইড আছে 3টের থেকে, আর 2টোর থেকে এসেই দুটোর মধ্যেই No, no, it was not circulated. It was circulated, but unofficially.
Called me and said
Yes, yes, unofficially. But because
it doesn't matter.
see, the difficulty is someone says, no, I don't want it. So that is the reason why I don't officially circulate the name.
There may be some persons like Mr. Banerjee that I am opposing this name.
Mr. Banerjee, yes, yes, not bad.
No, opposing.
No, it's
that
got a different matter.
See, always.
Yes.
I mean,
It matters when I'm paid to do it. Otherwise, I shall never. At the cost of payment. Otherwise, no.
You'll not be here. You'll not be. Yes. 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 I could not go through the file, sir. But I've asked him, I'll go through the file. And if it is there, I'll place it. Either 16th or 17th.
17th, 16th, my lord.
Whichever day. If I find urgency, I will. ওই মামলাটায় ফাইলটা দেখা হয়নি। So আমার পাঠাওনি তো তুমি। পাঠাতে হবে। It'll appear.
17th, my lord, it will be convenient for 17th or top.
It'll appear.
And top, it was in the top. When a
Appear, it'll
cooperative matter, it was in the past.
ডাকো, please ডাকো।
Delegation item.
Yes.
May I point out what I will submitting that last month's upgraded motion.
All those will be there, sir. Wait.
Well, the 7 matters were there in the last stage, before the monthly list came out. And today, my lord, out of the.
Please understand, Mr. Sharaf. I'll tell you. What I have done is I have included some of the matters from that list, some from the urgent mentioning list, but all will be there by the end of this month under the heading urgent mentioning.
Well, I'm just about the system. I just want to point out that it is not for myself. That well, out of the 7 matter of the last week's upgraded motion, there is one matter, and all except one. One is a dairy matter. Others are newly upgraded. What
Yes.
I'm just humbly requesting is that what is already upgraded in the last month,
I'll check up.
That should get some precedence of
I'll
next
check.
month's upgrade.
I'll check up.
That is what all that I'm.
Yes, I'll check up.
Your lordship.
No, not now. No mentioning now.
I'm just last Thursday's list.
No, list is there with us. The list is there with us.
Lordship, I'm
Yes,
not
yes. Call the
mentioning.
list.
Lordship, I'm not mentioning anything. Lordship.
Lord, I'm praying for the petitioner. Lord, under 276 A, Lord, if there is a failure to file TDS, then you have to take leave to prosecute. Then sanction to prosecute is given under 279(1). So far as we are concerned, there was a delay in filing during that period of post March 2020 when the COVID
March
period
2020.
March 2020. There was a period of delay, it ranged from a few days to a few months. And the amount which was involved, total TDS we were to pay for the year 2019-20
Return was required to be filed by?
Return was it was filed within the total period permitted of that financial year. 2019-20 is what we are concerned with.
2019-20.
That's total TDS 14 crore. Out of that 3 crore 68 there was a delay in paying. Now we paid it, which is provided under 201.
The returnable date of return.
Date of return, I'll show that. No, date of return, there was delay in depositing the TDS.
I understand.
Yes.
X is the date for filing it. There was a delay of Y.
Correct.
Identify that.
Yes, that is there. The list is there.
Show me that list and then go.
Very well. Page 67, Malad.
You want to take advantage of that COVID period?
No, Malad, two things. Malad, first is, I have paid with interest. Now, 276 says default. Whether delay is also included in 276 or not, we read it together. I don't think it is included unless there's some cases to say it is included. Now, I am quite naturally, I paid with interest, whatever they wanted me. And plus, the question of the COVID period. Both taken together, I am now challenge is the prosecution sanction which they obtained. Otherwise, they'll lodge criminal proceedings against my clients unnecessarily. Page 67.
That they're entitled to in law.
Not there's no default.
একবার দাও ইনকাম ট্যাক্স একটু ওখান থেকে বের করে You are saying without that default is the sine qua non for initiating proceedings.
At least, my lord, my understanding, my lord, is that.
এটা নয় অন্যটা দাও আচ্ছা ঠিক আছে এটা হবে ঠিক আছে ঠিক আছে yes 276
Yes. 276
subsection
capital এটাও আছে
subsection willful attempt to evade tax C
no A and
failure to
276
comply with the provisions of 178 no this is not the one
কোথায় গেল
failure to comply with
276B
yes tax deducted yes correct
and then my lord kindly read my lord with this section 200 and 201. Consequence of failure 201. I'm sorry, my lord. 201.
no this is not your case of failure to deduct failure to deposit
Deduct and deposit.
you deducted but you did not deposit that you have stated
Yes.
you deduct 276 is
No.
Does not deduct or
My lord,
does not
201.
pay to
Yes,
two aspects
correct,
one is
correct.
deduct
One is deduct and one is pay.
correct and 201 is deduct
No, also pay, my lord.
yes which part
201.
deduct or where the person including
Refer to also being an employer does not or does not pay. After my lord B does not deduct or does not pay.
yes
Or after so deducting fails to pay. The whole or any part of the tax is required by under this act, then such person without prejudice to any other concept which he may incur be deemed to be
no this
assessed in
is a
default.
separate provision that is a here an assessment is there under 200
Yes, my lord.
the principal officer such and fails to deduct the whole or part of tax in accordance with provisions of this chapter such and such so is not deemed to be assessed in default in such
Before it was detected, it's not that it was a question of detection. We have only paid. Right? On our own, we have paid. We have paid on our own voluntarily. my lord. There was a delay, and which my lord, they accepted with interest.
simple interest only
Yes.
as per the section itself
Yes.
1% for every month
Failure to pay. Delayed payment.
And 276B.
so what is the proviso to this section there is a proviso
Yes, my lord.
to section 201 that is the third proviso
Third proviso. 1. Provided further that no penalty shall be charged.
provided that in
under
case of
1A, my lord is looking at, or 1, my lord. 1 there.
201 this is under fails to deduct or pay
Yes.
now there is a third proviso that is under 1A
1A,
first
correct.
proviso under 1A
Correct.
right that says provided that in case any person including the principal officer of the company
Fails to deduct.
deduct the whole or part of the tax in accordance with the provisions of this chapter on the sum paid. So first of all, you have failed to deduct.
No.
Oh, your case is you do not come within this. So you are an assessee in default.
No, my lord, I have, yeah.
Having
My lord,
regard to this, you will be an assessee in default. Only you will not be an assessee in default when you don't deduct. See, looking at this proviso.
My lord, it says, if my lord, we look at 2011,
Yes, yes.
where any person, including the principal officer of the company, who is required to deduct any sum in accordance with provisions of the Act or referred to in subsection 1 of being an employer, very well, does not deduct or does not pay,
He'll be deemed to be an assessee in default.
or after so deducting fails to pay the whole or any part of the tax is required by or under this Act, then such person shall, without prejudice to any other consequence which may incur, be deemed to be an assessee in default in respect of such tax. Provided any person, including principal officer, that may not be required that. Then 1A.
But you already by this time become an assessee in default.
But I have two things. Now, can you read with me 276B?
Yes, yes, yes.
Two 276B is the charging section. If a person fails to pay,
How can you ignore this section then?
no, then it says fail to pay. Two things very important. One is before any deduction I've already paid. I paid within that year itself. That's why I was showing page 67. I'll come to it. Second of all, the COVID exception will also come in. And thirdly, even when show cause notice was issued, by that time also, everything has been
ascertained from
paid.
Yes, Mr. Bhattacharya, what is your case? You have determined penalty on him. Levied penalty? No.
No. Sanction to prosecute.
Come to 201. 201 is two folds.
78 prosecution.
Provided for that no penalty shall be chargeable under subsection 221 from such person unless the assessing is satisfied that such person without good and sufficient reason has failed to deduct and pay such tax.
Yes, he has not failed to deduct. He has deducted.
Failed to deduct and pay. He has deducted.
Deducted, but not paid within specified time.
Correct.
Under the subject to lawsuit correction, we had section 200 and section 276B conjointly.
200 has to be read. Duty of the person to deduct. That he has deducted.
No, any person deducting any sum in accordance with
I see. With the prescribed time.
Here this case is not the active case. He not has not deducted tax
Within the prescribed time.
admitted from the payment.
Correct.
Has paid tax after the prescribed period, and his contention is that at that point of time that COVID is going on, and for that reason he has not paid the deducted tax in the prescribed time. But it is also true that he has paid that tax thereafter. Not that he has not paid, but he not paid in the prescribed time. Here the case is that he has failed to pay tax in prescribed time 1 month to 16 months. The delay is 1 month to 16 months.
For which he has paid interest at the rate of 1%.
He has voluntarily paid.
Pardon?
Voluntarily paid.
Yes. So that shows his bona fide.
Yes, so, but our contention is that he has not paid in the prescribed time limit. His prescribed time limit is he has here is the COVID started with 2020.
I've checked up that. I've checked. Yes.
Report with 2019 to 2020 March, 1st April 19 to 31st March 2020. He has deducted tax from various persons. But his first schedule to be paid these TDS from 1st April.
Under 139, section 139, as per 139.
1st April, May, June, July, April to June, he has to pay within July 31st.
Which he has not.
Yeah, he has paid something directly, part by part, but not within the prescribed time. Now that prosecution has been lost, and here you have to kindly see the sanction order.
He has not challenged that sanction order. Challenge it.
Yes. My lord, I'm sure, my lord, there are better matters for income tax to pursue, my lord, to prosecute,
Yes,
my lord.
Mr. Bhattacharya, take
Someone, my lord,
instructions in the matter.
who's, my lord,
You see, at the end of the day, Mr. Bhattacharya, you see, at the end of the day, he has paid. You did not launch any prosecution for him to pay. You could have. Provision is there.
We have taken the sanction for prosecution.
That is enough.
That is 27th of
No.
That is enough.
2025.
Take instructions in this matter. Which page is the page?
my lord, the challenge, my lord, the sanction to prosecute, my lord, which is challenge page 39.
39. Let us see the
This is
sanction order.
27th February 2025.
What does the sanction order say? The detailed sanction order. He was heard.
Yes. But before that, we got two so-called notices.
Yes,
Yes, we replied also.
One not replied. Thereafter, second so-called notice, he has replied, and complete reply has been given second so-called, final so-called.
Para 4.2 at page 40 says no outstanding demand and default as far as the position reflected.
June 2024.
His contention was unless default is detected, it is not default. So
But before we detect,
And your notice is 24
21st.
and I paid before that with interest.
what is his past conduct? Anything?
No,
I
nothing.
want to take instruction today, because
Take instructions. I'll place it on another date.
holiday, there is a holiday because I not able to take.
Don't proceed on the basis of sanction. I'm not recording an order today because without your instruction, I cannot record that. Yes, next week I place it, but don't proceed on the basis because since the matter is sub judice now.
Next week, not able to.
Tomorrow, no. Tomorrow, these matters I don't take up. You are aware. Why? You will not be here. Very well. I'll place it Monday week.
Monday week was Monday 22nd.
22nd. I'm taking it.
Abide by the result, whatever. I'll provide for that. Otherwise, they will, if they initially.
Not to initiate, Malad, just to maintain, Malad.
No, since he's taking instructions in the matter.
So, Malad can record that, Malad. He wants to take instruction and Malad.
I'll record. Whatever steps are taken, we'll abide by the result. I'll provide for that.
Malad, if Malad launches, Malad, I'm sure he will not, but Malad.
He doesn't know what has happened up to now.
No, it's not been, Malad. No prosecution has been launched. Malad, that's why, Malad, the order, Malad, is of 2020. Malad, just.
February 2025.
979.
Correct. 279(1), where Malad they take sanctions.
The issue involved in the present petition is whether a sanction to prosecute Then again Wednesday.
23rd.
Now I'm taking up the
On Wednesdays and
the cooperative matters are on Tuesdays.
oh, I'm sorry.
23rd.
Then 23rd, my lord, is a Wednesday.
Mr. Bhattacharya is in the receiving end. It's not matters are not being heard.
Okay, income tax is not being heard.
On 23rd, Mr. Bhattacharya, take
Great.
instructions on this.
So,
But still,
my lord,
yes, naturally. So it should come to an end. Matter should come.
I think, my lord, that's why I said, my lord, the other, my lord,
Yes. Matter should come to an end.
more serious matters, my lord. This is, my lord, something. My lord, the affidavit of service.
Of service filed in court is taken on record. So Mr. Banerjee achen, and Mr. Banerjee learned senior advocate.
Without instruction, I
And quite naturally.
Actually,
Quite naturally. Very good. Grateful.
Very deeply.
yes, Mr. Chakraborty.
But it is that matter, betel nut, sample, no relied upon documents given, hearing for provisional release, adjudication done. If your lordship can recollect, that relied upon documents we have asked for, not given, and
So I was in the process of disposing of this matter on the last occasion.
Correct.
No.
Correct. And now before my learned friend is supposed to
I
answer.
will not. There is not much time today.
Yes, before my learned.
Do this, Mr. Bhattacharya. I'll place it on Monday.
My lord, before my learned.
Instead of Monday, my lord, kindly take some next Thursday because the department, my lord.
Thursday, I carry this. Today is Thursday.
Then wait just a minute.
At 2 p.m. this matter cannot be taken up. What is your apprehension?
Nothing at this juncture.
From the very first day, that was the apprehension. This has happened.
What has happened? Tell
My lord, he misdeclared the goods.
Yes.
As a roasted
I am the
now, my lord.
I am the heinous offender of this world. I am the heinous offender. But still I have a right of trial. Matter is going on before your lordship. Learned friend is to take instruction and come back. They are proceeding for recovery on the basis of that order. That is why from the first day we pray for an interim order.
Since Mr. Chakraborty, learned advocate, represents hear these matters in the morning.
Yes.
Thursday afternoon, too short a time, Mr. Bhattacharya.
Cannot be complete.
Yes.
My lord, instead of your lordship has state this letter,
Yes. Notice.
will it be your lordship pleasure?
No, only the notice is stayed.
The notice and action they are under.
No, only the notice is stayed.
Tomorrow they may issue a fresh notice.
Nothing more. I have not heard it.
Tomorrow,
I'm hearing. If they proceed, you come again.
very well. If they issue
No,
fresh
Bhattacharya,
notice,
I'm hearing.
I will come again.
I'm hearing. I will hear you. I'm giving a hearing to you. It may be that petition may be rejected also.
Yes.
But in the meantime, if you proceed to frustrate the court's business, then it becomes difficult. This was not expected.
No, my lord. This department.
Very well. I'm not blaming you.
Gardening
You are my officer.
My lord, this is the gardening
What
department.
happens in other matters, court considers that whether I should put in this protection or not. Because once it goes out of the hand, it becomes, things becomes complicated, no? Yes, call the next matter.
Deeply placed.
Item number 6.
Yes. Continue, sir.
Lordship, I am for the petitioner, Lordship. Your Lordship, there is a appeal has been rejected on the ground of delay, Your Lordships. That is the only ground for rejection.
Notice was issued, Your Lordship, in this matter. If Your Lordship kindly
Difficulty,
comes to
Mr. Sharnal, today we are in real difficulty. You see, then this court has to decide this matter.
Lordship, SK Chakraborty has been stricto sensu followed. Show cause notice was issued that you have to explain the delay. They have
Take
failed to explain.
instructions, Mr. Sharnal, whether you are ready and willing to hear the matter on merits.
No, merits, Your Lordship. Your Lordship, kindly remand back then.
Take instructions and come back. He has, after all, an adjudication order. Please understand, a right of appeal. Why? You see, scheme. What is the scheme? I have by this time I have understood the scheme to the little extent that I have understood. Why a pre-show cause is given? Why? Because these are accounting procedures. Today, after a pre-show cause is given, he comes up with an answer. And in the answer, it is found out that he has some material, but that may give rise to something else. Something else which needs to be considered. So therefore, that is included in the show cause. To benefit you practically, not the assessee more. It is to benefit you on the basis of his representation. The shortcomings will be corrected by you. And you will place only those facts by ironing out the excess additions that you have made. So confining it whatever you want to. Now an adjudication order is passed. The statute recognizes an appellate authority, inbuilt provision of appeal.
Appeal is there.
Ordinarily, why will a person not file an appeal? Ordinarily, why will? Unless he does not want to challenge it. He is interested, he is paying GST, he is in business. He may have missed out the position. Then after the appeal, our other remedy has been provided, tribunal. All are fact-finding bodies, all of them, fact-finding bodies. What the appellate authority can do, the same can be done by the tribunal. See, the act is very clear.
It's very clear, Your Lordship.
High Court is exercising supervisory jurisdiction. Now, High Court has to entertain this matter. Heaps of matters will be here. The matter will not be decided. The most important part, revenue will
suffer. That's true, Your Lordship.
Revenue will suffer. So, in the interest of the revenue, it is necessary that these matters are disposed of. Because once it is disposed of at this stage, he will have no say.
Absolutely, Your Lordship.
Most of the cases, I don't want to comment on his merits because I have not heard him. He will be saying that I become prejudiced. No. But some of the cases I have seen, not much merit in them. Maybe 1 or 2 points. 90% matters have very little merit, but some do have some merit. Some have. So you cannot ignore them as well. Have to decide. So take instructions on this
Lordship,
matter.
there's nothing to take instruction from.
Send it back.
The only because I wanted to bring this fact into this thing into Your Lordship. And
You may challenge the order by saying you may support the order by saying he is correct in dismissing the appeal.
That is the only thing I was saying.
Consider this. His adjudication order was passed on merit.
Yes, Your Lordship.
after hearing the parties?
Lordship, there was no personal hearing given, but I'm not pressing on that point, Your Lordship. I'm not pressing on that point.
On the appellate authority, it was show cause was issued.
Your
They did
Lordship,
not.
Personal hearing was not granted to you?
In appellate authority, it
No,
was
no.
Adjudication stage, Your Lordship.
70,
adjudication.
73.5,
73.5.
4. 73, 4 or 5, which one?
75-4.
75.4. Personal hearing was there, ought to have been granted. So I'm not going back to that stage. So he did not get an opportunity of hearing as of today. Please understand, Mr. Sannal. Advise your officers accordingly. It is not the question of writing a 10-page order on section 5 and not adjudicating it. He is not there for that purpose. Judicial authorities are there who will decide when an application under section 5 is to be allowed or not on this aspect. If there are serious legal acts, he will decide whether he has any merit or not. Let him consider this aspect, especially having regard to the judgment delivered by S.K. Chakraborty today.
That is the only difficulty, Your Lordship.
Ashun.
Your Lordship, one more very small fact, Your Lordship. My bank account, the urgency was that because the bank account has been attached and more than 10% has already been recovered, Your Lordships may kindly release the bank attachment.
Then I have to
Then take
then I
instructions.
have to
Lordships,
Then take instructions.
Yes, Your Lordship.
Considering the fact that the bank account of the petitioner has remained attached, and since the petitioner asserts that
for troubling Your Lordship. Before Wednesday, the officers are closed, Your Lordship. Kindly gives me a
21st.
date.
21st.
21st. Yes.
In this matter,
Mr. Sharnal, take an approach which helps your office also, because it is nothing personal about an officer. It's the state's revenue which is revenue will suffer, because the litigation pending with this court will not help. I will send it back under any circumstances,
They should follow the.
because the matter pending here will not help anybody. Iron it out, finish it off these matters.
in this matter,
Yes.
This is a matter. Lordship, in this matter, as per the law stand as of today is completely against me. S.K. Chakraborty will glare at me. And then if I say it is stay, then Piyush will glare at me. The state of West Bengal, Piyush Kanti Chaudhary. Piyush Kanti Chaudhary will glare at me. That stay does not seem that it is not operational.
You are aware of all the aspects, Mr. Banerjee. Tell me what to
My lord, the fact
No,
is
that's
that
what I'm saying. Bank account attached.
no, my lord, it's a cancellation of registration for non-filing of return.
I know very enough. But if you
My
have
lord,
no,
similar order.
I am not making any observation. I'll directly send it back. It will be easier for you.
What I'm saying.
Yes.
Well, if the number can be reinstated, we will file.
Let's not take a very shortcut. Lordship is bound by division bench and the recent judgment of Justice HON'BLE Bhattacharya passed in January 2025. January 2025. That is also passed by the Lordship's coordinate bench, which also affirms in the line of Justice Bhaskar Bhattacharya's judgment that this. But so far as Lordship, other high courts are concerned, Chennai and Delhi, Lordship, there
And
they
this
say,
is passed on Monday.
No,
So
that's
this is actually my matter only in regarding condonation of delay, where section.
no, Lordship, what I'm trying to
Yes,
understand and saying,
Lordship, so far as other High Court are concerned, they are saying when a order operation is stayed, it is not only between two parties to that litigation.
Yes,
Is the
yes, you argue that on a better matter, Mr. Mr. Banerjee. Not,
Lordship, I thought that I should say the
No, no.
candidly the provision.
No, no, no. What
Because
I am
none of
bound,
this judgment
I am
has-
bound. What I say, this court is bound by S.K. Chakraborty. What is the matter on?
S.K. Chakraborty was a state of
I had
Bengal,
followed
Lordship,
that,
Justice-
Ambika Ma Amba also.
Yes. No, Lordship, this
No, I
is-
cannot.
Yes. I thought you informed.
I cannot. I am bound by that, and I will not go there. I will not go on that
Lordship,
issue at all.
Lordship is not bound by
Challenging the
8, 9, 10 are together, it's the same issue, different periods. Here they are.
Name is the original side. Complete it.
Lorships. Then Lordship next Thursday, because it will take some time. Lordship. Otherwise, your original side matters as your Lordship says. Otherwise, next Thursday.
It will take some time.
It will take some time. A copy of the writ petition.
I have served already. I have affidavit. I will still give one extra copy.
You have not received copy.
We have not been received from the
Affidavit.
They may.
Mr. Bhattacharya and Mr. Dey, learned advocate representing the respondent
tomorrow to my lab.
আলাদা আলাদা order হবে সব কটা। Give me the page numbers in all of them.
For the
recovery
dates or the notices, your lordship. I will write and give lordships.
Yes, এইখানে না এই যে দেখো এই শোনো ওই যে লিখেছি না by issuing a notice under section 79 আছে না ওখানে আছে না
Next is in the next is page 34
of the said act আছে 79 of the said act date 8 বলে ও যে ডেট গুলো
dated 10/5/24 in both. In first two, 8 and 9, both dates same, 10/5/24.
1 and 2 10/5/24
And the third
pages
in the second date it is page 34.
second date page 34 first page
First day lordships it is page number
পেজ গুলো মুড়ে দেবে দেখে নিও একবার চেক করে
page number 45.
page 45
And the third lordship I am telling.
শুধু এই ডেট গুলো সব কটা
In the third it is
otherwise it becomes very open ended you see I don't know whatever
third also date is same, page 38.
third is date same page 38 fourth
Three only, three date petition. 8 Great.
because otherwise it becomes very it is limited to that notice only.
Lordship, my prayer
at page dated appearing at page blank of the petition.
in the third lead petition there are multiple notices after this also.
Maybe, but
Lord.
still then
Quite natural, man. You should reminder one.
No, not reminder. Three wings of the same department for the same period giving separate values. One say 100, one say 200, one say 150.
no gossip stress be taken
Lordship.
the next day.
Lordships. Much.
Next day ডাকো একটা আছে
Grateful.
so your matter has been called on. So anxious from the morning while
No, my lord. Actually, yesterday we.
I
waited for
understand.
the
I
whole day.
understand.
Not
he had
enlightened, my
also
lord.
been on the other side, so he understands there's a lot of pressure.
My lord, actually, I was not with respect to this matter. My lord, what I was trying to point out
Continue
is
because
that.
there are other matters in the original side.
Yes, my lord. My lord, the short issue, my lord, in this petition is that by virtue of section 128 capital A, my lord, a benefit has been extended, a amnesty scheme has been issued, which, my lord, grants amnesty from the payment of interest and penalty if the notices or order has been issued under section 73. So if it is a case of my lord, not without willful suppression of fact or without any intent to commit
For a particular period.
for a particular period, for the first three financial years, 17, 18, 18, 19 and 19, 20. For these 3 years only,
No interest and penalty.
no interest and penalty. Even if suppose the matter is pending at the appellate stage or any other stage, that appeal can be withdrawn and the benefit can be extended. So, my lord, now the circular has been issued, but the limited challenge is, my lord, that the circular has been issued, my lord, which is from page 61 to 75.
Which is what is the challenge in the circular?
My lord, the circular, my lord, says that the benefit of this scheme is not available if the levy of interest and penalty is on account of delayed filing of the return. So my limited, my lord, submission is that the circular cannot whittle down the benefit extended by the act. My lord, it is a, my lord, the Supreme, there are a number of Supreme Court. In any case, my lord, the circular is for the purpose of clarification of how the benefit has to be
Just a
availed.
minute. Show me the section and then the
My lord, section 128A, my lord, Finance Act, page 56 onwards. Kindly refer to page 56 onwards. My lord, section 128A is on page 58, my lord.
Serial number 146.
146 of the Finance Act, my lord. (146), my lord. 128A. Notwithstanding anything, shall I read out, my lord? Notwithstanding anything to the contrary contained in this act, where any amount of tax is payable by a person chargeable with tax in accordance with a notice issued under subsection 1 of 73, or a statement issued under subsection 3 of 73, or where no order under subsection 9 of 73 has been issued, or an order passed under subsection 9 of 73, and where no orders under subsection 11 of subsection 107 or subsection 1 of 108 has been passed, an order passed under subsection 11 of 107 or subsection 1 of 108, or where no order under subsection 113 has been passed, pertaining to the period from 1st July 17 to 31st March 20, or a part thereof, and the said person pays the full amount of tax payable as per the notice, or the statement or the order referred to in clause A, B, or C, as the case may be, on or before the date as may be notified by the government, on the recommendation of the council, no interest under section 50 and penalty under this act shall be payable, and all the proceeding in respect of the said notice or order or statement as the case.
Where it restriction? Where restriction, page 60?
Page 59.
That is all right. I've seen that.
But the restriction in the circular starts from 61, my lord.
The relevant is.
And the relevant page is on 69. Page 69, my lord. My lord, paragraph 4, my lord, table 4. But I'm reading out the question, whether the benefit provided under section 128 capital A will be applicable in cases where the tax due has already been paid and the notice or demand.
Yes, my lord. What is your contention on this?
My contention will be the first qualification will be tax. Now over here, there is non-filing of return which has resulted in demand on account of interest and penalty. The qualification under 128A, Lordship will kindly see, the first and the golden word is when any amount of tax is paid.
Very well, I'll place it for hearing. Means for orders on immediate. Hearing means?
Yes, my lord.
Because this is small issue. I'll record that you will not file affidavits.
No, we will file affidavit.
And what affidavit you will file on this?
Kindly, my lord.
What is this, Mr. Banerjee?
My lord, kindly, my lord. There are we do not. If we have some control, then there will be no problem. But we are dependent upon the hierarchy of the department, which says that you should file opposition. Now, at that point,
affidavit you will file.
And this is an interpretation of the circular, not even the act.
If I cannot, then I will argue on the question of law.
1 week.
1 week, 2 weeks.
1 week should be sufficient.
2 weeks.
2 weeks.
2 weeks. Within 2 weeks, we shall.
The issue that falls for consideration in the present petition is whether the
If I find time, I'll take it up. Because there is no hearing date, Mr.
Additional determination has
yes.
come. Additional determination.
Additional determination is there. There is no hearing date.
But the difficulty is that
Mr. Sharav, I don't have a hearing date. Previously, Thursday was a hearing date. I would have decided this. But
no,
now
that is why, my lord, I am requesting, my lord, that in this matter where just interpretation of circular is involved.
Let it remain in May. Let us see.
Let us see.
My lord,
If it is possible, you mention, I will take it up.
My lord, the difficulty is that the last date for filing that SPL2, the form for the availing the benefit, will expire in June. So after that, my lord, even if, my lord,
you file it,
but then again it will lead to fresh.
You don't accept it, it will be rejected. But still, then you have a cause of action.
My lord, that again it will
According
lead
to you, you are entitled to. According to them, you are not entitled to.
But as per the form, it will lead to fresh round of land. My lord, 70-80%, my lord, SSCs, I believe, will be, my lord, affected by this circular clarification. Because, my lord, 73 demands are issued only on account of delayed filing, as far as I know or understand. So, unnecessary, it will lead to flooding of the litigation on a fresh issue where they will reject this SPL 02.
But I take it that in your case, your return is delayed.
Yes, my lord.
You have a cause of action.
My lord, it will just lead to.
No, you have a cause of action of your own in this matter. I will examine that at the time of final hearing.
My lord, this issue, my lord, why
I will not because you are not espousing the cause of everyone. You have to demonstrate
that is
you have
not,
a
my
cause
lord,
of action.
what I'm submitting, my lord, that it will just lead to, my lord, the flooding of another, my lord, litigations.
Finally, yes, call the original side matter.
My lord, if your lordship can keep it after 2 weeks, my lord, your lordship was already.
Monthly list of me.
After 2, my lord, kindly fix a date, my lord, for.
No, it has to come in month.
Kindly, my lord, kindly keep it on a particular date, my lord, that, my lord, that the issue will get concluded, my lord. Kindly keep it on a particular date, my lord.
Yes, call the list. Original side.
I crave leave to mention two matters, Your Lordship. When Your Lordship have received instructions to withdraw the writ petition, Your Lordship. Item number 45 and 49.
Yes, call that item number 1. Mr. Khaitan is waiting for withdrawal.
Original side. Withdraw. Grateful.
File does
My lord, my senior is Mr. Sharma is not in court number 654. So please give password.
Well, Mr. Roy Chaudhary, we've been in touch with him. He said he'll come to start.
So file does on.
One to six. My lord might 1 to 6. My lord might recall me, this was the case where I had offered to tax the entire amount paid to me by the company as salary. But it was a provisional amount because the central government approval had not been received. And during the pendency of the application before the central government, the law changed and the application abated. And the central government said, now you have to follow the new law, which required me to go back to the shareholders and get the approval. And if there were lenders, I had to obtain their consent also. So the company, the company then considered the position and then they asked me to give the money back. So this happened in December 2019. They asked me to give the money back. I gave the money back within about 2 weeks. And within a month of that, I approached the commissioner under section 264 because my return had been accepted as filed and there was no proceeding open in which I could raise this point. So I invoked the commissioner's power under section 264 where he can pass an order. If I am prejudiced, he can pass an order considering my application. The other power is under 263 where the commissioner exercises the power where where the order is erroneous or prejudicial to the interest of the revenue. That is 263. 264, my lord, is the power given to him to act at the assessee's on the assessee's application or even suo motu.
Power of revision.
Yes, ma'am. Power of revision, 263 is where for the
Prejudice of orders prejudicial to the revenue.
lordship.
And assessee is 64.
260.
কি চাইছো? আচ্ছা আচ্ছা। Yes, but difficulty is without Mr. Sharma.
Lordship, they're on the way, on the last occasion, I had pointed out from the affidavit that the commission.
Affidavit টা দাও। Yes, affidavit টা দাও। They had admitted this.
Yes, no, that they have not considered it. Kindly see 3 paragraphs, paragraph 9, 10, and 17.
Which page is the order?
No, the order, my lord, will find at page 122. 122. The consideration is at paragraph 5, page 125.
So you said that he was.
Now, the only ground on which it was practically rejected was it was filed beyond 1 year.
That, my lord, and then also, my lord, on merit, he says there's no provision in the law to allow deduction from the salary income. My case.
No, according to you, it was not deduction. According to you, you were holding the amount in trust.
Lordship.
Because the company had sought for sanction, which they did not ultimately get.
Lordship.
And therefore, you returned the money.
Yes. Therefore, it was not income at all. So,
it did not constitute as an income, but by treating it as an income, you filed the previous return,
Lordship.
which you wanted to rectify by way of which you could not because of the delay, and as such, you invoke the powers under 264.
Lordship, because by the time the company asked me to give the money back, the time had passed. In fact, there are 3 years. My lord will find that 2 years there are delay. The 3rd year, then
I cannot direct him to. I cannot allow this.
No, he has to consider it.
Yes.
His own stand is that I have not considered it. Now, on that note, my lord had a query. What was passing through my lord's mind was on merits. Where do I stand? So I'm not inviting a judgment from my lord, but kindly see what the on merit itself. There's a judgment of the Honorable Delhi High Court.
My lord,
Coming.
Yes.
Please pass over.
If I pass over, I'll take an original side matter which is fixed, and that will continue for the rest of the day.
He's here, see, almost there. The escalator.
Mr. Mukherjee will be coming here at 3:30 sharp. Yesterday, I had to inform Mr. Khaitan, who was waiting here. So you ought to have intimated Mr. Khaitan in that case. Yes, which paragraph?
Kindly see paragraph 4, the facts.
Yes.
And my Commissioner my lord, took note of the provisions of the Companies Act in paragraph 5. My lord, I've got those provisions. My lord. Same provision was there. It is in trust. It is
Identical provision.
I'll show that. My lord. And then my lord, if my lord is pleased to have the next page. Fourth line, my lord. The tribunal concluded.
No, this is not the question of foregoing salary.
Does not belong.
It is not part of your salary at all. Because this would have been a part of your salary had the relevant sanctions been there.
In fact, as far as the company itself is concerned, the law is that they cannot even get a deduction for what is not sanctioned. So they cannot even get a deduction under
paragraphs.
Lordship.
Petition paragraphs.
Lordship.
To be.
Yes.
This amendment without saving clause.
Yes,
No, it's all right. I'm just asking because I will not go into that issue.
It was provided that the application shall abate. So the applicant statutorily the pending application abated.
Oh, so it provided.
Yes.
So what happened to the TDS?
But that I had claimed credit in the return which I had filed and I adjusted it against my tax liability. So normally that stands paid to the government in any case. So now when they will refund to me, they will give it back to me because that company had deducted and deposited. It goes to my credit. It is adjusted against my tax liability. So when the income will, if the commissioner accepts my case, then he will direct assessment of the lower amount, in which case the tax including the TDS, whatever the amount that they will refund to me.
But what happens to the TDS? That's a huge amount, 10% of the 10% of your remuneration.
Lordship.
Now your remuneration is not there,
Lordship.
but the TDS is there.
That whole thing will come back to me because there's no that.
Then how can the TDS come back to you? The
It will
TDS
not.
has to go to the company.
No, but once it is,
You have returned the money to the company.
I have returned to the company the entire amount, including TDS. The entire.
Where have you said so?
Kindly see the amount which was, kindly, if I may draw attention to the letter where they asked for the gross amount back.
No, TDS is 1 crore 10 lakhs. No, this is.
But if my lord is
1 crore 10 lakhs.
Yes, Lord.
And gross amount is
3 crore 21.
3 crore 21. So you returned 3 crore 21.
Kindly see that page.
Yes, Mr. Sharma. Then there can be no difficulty. Yes. Oh, Mr. You on the last occasion said that you are appearing for Union of India. No. You are for the income department. Yes, Mr. Rachudi.
Order of 64. Before this one. Now, while we rejected the 264 application only on the point of limitation. Kindly see the order.
Yes.
There is 6 petition that in 190. The first one.
64 has to be filed according to the return had to be filed within 1 year. Now he says that he could not have filed the return within 1 year because there were reasons for the same. He gives an explanation. Right, wrong, indifferent, that is a different issue. Now 264 gives you power to decide this. Two 64 does not have any limitation, does it?
Yes, no. Subsection 3 and the proviso.
Proviso gives the power to condone the delay.
Never condone the delay.
Where have you considered that? Where have you considered that?
There is a condemnation of delay petition before your lordship. My lord can grant it, my lord cannot grant. Both the options are open.
No. You see, it may be a discretionary exercise jurisdiction, correct, Mr. Roy Choudhury.
The discretionary power of the court was.
But the discretion has to be exercised judiciously. So where is the exercise of discretion in this case?
Our appeal in the department where we filed 260 application and there was a delay. Well, this honorable court has rejected our application on the point of delay itself.
How so many?
On the point of delay itself. The delay issue is the discretionary power of the court. He may accept it, he may not accept it. Well, I can show judgments on this point by our appeal, which by this court has rejected. If I am not wrong, Tata Metalics, in my case, Malad, if the delay was rejected by this division bench of the Honorable Chief Justice.
This court may have rejected that, the division may have rejected that application on the facts of this case, of the case.
Only on the point of delay, not on the point, because when we prefer an appeal, challenging the order of the Income Tax Appellate Tribunal, there was a delay, so there is a Section 5 application. Then
So in those
appeal.
facts, what facts the court had rejected,
There is
then you have to show me that judgment.
I'll show.
Show it.
I'll show, Malad, regarding that point.
Show it, that is the only issue involved.
Because of two reasons, Malad. The delay point is there's a stay petition memo appeal. The moment delay petition was accepted, everything gone.
Show me.
Malad, I'll come back with the judgment
Right.
tomorrow.
But kindly have a look at the judgment of our court on this note. In the 264 matter, But this is an admitted case where commissioner says I have not considered the explanation. But
No, your affidavit says otherwise. Have you seen your affidavit? Read paragraph 9 of your affidavit.
Page 797, kindly have. Judgment of our court, my lord. 797, the placetum F.
No, the court can certainly, Article 226, court can certainly consider whether a discretion has been exercised judiciously or not. That the court has
The admitted case of non-consideration.
Show me a judgment. Show me the judgment, Mr. Where you want to? No. You want to show me the judgment because today you'll argue, on the next day you'll show me. Then no point. I'll decide it either in your.
Kindly come to page 125, paragraph 5. The order of 264.
Yes.
It is seen from the record that the return of income under such and such for the assessed period such and such was filed on such and such date. The state return was processed under section such and such on such and such date. The revision petition under section 264 was received in the office of the Principal Commissioner Income Tax 2 on 17/1/2020. The date of limitation for filing revision petition under section 264 expired on 2018.
Correct.
Moreover, there is no sufficient reason to condone the delay of more than 1 year, 7 months in the instant case. Well, a similar order was passed in my case, my lord, which was the report.
What is his case? Why he has come this late? You show me, Mr. Chaudhary. See the dates he has disclosed. 264 petition would not be required to be filed by him. Had he rectified his returns immediately, there was a time limit for rectification of his returns. But his case is he could not have rectified these returns within that time. Now you show me that is cause of action for applying under 264 had arisen on one date and he has applied on another date. Show me that. And therefore there is no sufficient cause. Or he could not explain the sufficient cause in his petition. Where is your petition?
Lordship, kindly have a look at the petition. Lord,
very well, you come up with the judgment.
Yes.
You come up with the I'll place it on to Wednesday. We read this next week.
Yes.
Huh? Next week, no, Mr. Chaudhary, be here. What tomorrow? Tomorrow I don't take up these matters.
Then Monday.
Monday. এই আমার জাস্টিস চক্রবর্তীর সঙ্গে একটা ডিভিশন বেঞ্চ আছে কবে আছে দেখো হয়েছে কিনা দেখো
But only on the point of delay, department was suffered like anything before this. In 100 matters, we lost in 90 matters. Only on the point of delay.
His case is the remuneration that he received had to be returned because the company was not competent to make over that remuneration to him. Listen, try and understand. Since he had received that remuneration, he filed returns by treating it as his income, though in fact he was a trustee in respect thereof. After the application filed by the company abated by operation of law, he returned the entire money along with the TDS to the company. And thereafter, by that time to file rectified returns expired, he applied under 264. When he applied under 264, the time to file application under 264 also expired. So therefore, he sought for condonation of delay. whether in the facts there was sufficient ground or not, this to be considered. He said one line, no sufficient ground for condemnation, no, nothing more is necessary. But these facts are required to be considered. I'll hear you. আর মিস্টার কি হলো কবে আছে কি হলো আছে 16 তারিখে থাকার কথা তোমরা রাখো না কেন দেখো না কেন because this matter cannot continue for ages. One day I've already heard this very short point involved, Mr. Roy Choudhury. If you want to show me any judgments, show me judgments. And Mr. Khaitan has relied on NITCO Corporation. So this is on the while exercising. আছে তো বলো না কেন তোমরা so therefore power court exercising jurisdiction of judicial review whether the court is competent or not.
Two option either my lord will accept this writ petition or remand it.
Yes, when I accept I cannot allow you see I cannot say that 264 is allowed for whatever case he has. So therefore his 2C application under 264 has to be hard on merits. Either it will be hard on merits or it will be thrown away.
So what
No, you want it to be sent it back to the authorities once again on the issue of no, I am not inclined. On that, perhaps if you can demonstrate, Mr. Roy Choudhury, this matter does not require further consideration having regard to his conduct and show me his conduct from the petition, or if you want to bring any document also, I'll consider, then I will not allow. But if I find that it is justified, then it is a different issue altogether. Sending it back only for the purpose of reconsideration once again, whether or not the delay will be condoned, perhaps will not be fair.
2020.
So that is why it is all the more necessary to decide it either this way or that way. Either this way or that way.
He filed the writ petition in 2023. There is another delay. Well, kindly fixed on Thursday, my lord.
Yes. The writ petition was filed after 2 years.
The full explanation, the pandemic intervened, Lord. There's an
21-23.
The entire explanation is there, Lord.
Writ petition was admitted.
Yes,
or simply any or.
No, but there's a full paragraph devoted to explaining, Lord, the
Consider
Conduct of the petition is also, my lord, is not acceptable.
on that.
Lord, paragraph
Chaudhary, I'll hear you on that issue.
Paragraph 14, Lord, it is explained, Lord. Page 16, paragraph 14.
That during COVID period, we lost 90 matters because of delay.
Heard Mr. Khaitan, learned senior advocate representing the petitioner, and Mr. Roy Choudhury, learned advocate representing the respondents. List this matter for further consideration on the same heading. Mongol Bishpadivar. Miss for us,
Last occasion, my name was not appeared in the my lord order.
you appeared for Union of India.
No, nothing was there, my lord. Neither Union
Now,
of not for India tax. And kindly include it. Otherwise,
It appears that in the order dated, it appears that in the order dated, you were there. Mr. Sharma was only there.
No.
In the order dated 7th April 2025,
my lord, today both of us lost.
the
because
appearance of
Sunday
Mr. Roy Choudhury has not been recorded. Full stop. Let the appearance of Mr. Roy Choudhury, the learned advocate representing the respondents, be recorded in the order dated 7th April 2025. Let this bas আর কিছু লিখতে হবে না correction কিছু হবে না। তুমি মেনশনটা তুলে দাও না তুমি মেনশনটা তুলে দাও ডাকো ডাকো 330 ডাকো Today is a contempt matter. No, it's all right. No, actually, you see, I was only indicating that today 3:30 this matter is fixed. So Mr. Khaitan was waiting, so I wanted to take up this matter.
I have given a message to proceed.
I would have disposed of a very short point involved.
What is that?
Your Mr. Bhattacharya, evidence was supposed to be filed today, but last day, hearing was concluded by 5. So I contacted them and today it's audit.
They have given instructions.
They just fought for a little time. That's it.
What is there?
That's the communication.
No communication, relearn the communication. They do not communicate with you, Mr. Bhattacharya.
No, they communicated. They said that
you want appropriate persons, I will direct the relevant person to come and appear before this court. If you are not getting appropriate instructions, tell me. What sort of communication is this?
They gave appropriate instructions.
What appropriate instructions? Take time.
They read, no. I have directed to
Tell me, I'll direct that person to be present in court. The matter is going on for quite some time.
No,
you are being not sorry to say, you are not favored with instructions, and the report was a document was directly sent to the court without a copy being made over to you.
No, copy was with me, but I couldn't open it. I couldn't open it.
Mr. Bhattacharya, if you want, I can direct that gentleman to come to what is necessary. Today, I want to ascertain whether there was any request. Only this much, nothing more than that.
Yes, that's why you also asked for an evidence. Just for an evidence. And they said today is closed.
After the matter hearing is concluded.
No, they can have the evidence.
Yes, Mr. Mukherjee.
Before my learned senior colleague starts, Malad. Lordships can hear me. Malad, will I be given about 15 minutes tomorrow, Malad?
Let's let Mr. Mukherjee conclude first. He's continuing.
Yes, because then I will think of coming tomorrow, Malad. I was scheduled to come. If Lordships is giving me 15 minutes, Malad, tomorrow.
Not tomorrow, Mr. Mukherjee. Tomorrow there are other matters. You see, tomorrow
I'll just otherwise, Malad, because I have already scheduled because yesterday there was some discussion. And I will conclude exactly in 15 minutes, not a minute more than that.
Assigned matters are there and it will be very difficult. Anyway, let us see. Let Mr. Mukherjee conclude.
Very well.
My lord, for completeness sake, my lord, I thought I had concluded on confidentiality. My lord, there's one judgment, my lord, which I wish to cite. My lord, of the Guwahati High Court. My lord, on confidentiality, my lord. My lord, it's a my lord, this is, my lord, of 26th August 2019. My lord, kindly take, my lord, paragraph 41. My lord, I want to show your lordships, my lord, the findings on Rule 7. My lord, may I indicate the para numbers, my lord, and then place them, my lord?
Just a minute, just a minute. Yes.
May I indicate the paragraph numbers? Para 41 to 44. 57, 58.
Kindly share this copy to Mr. Sharma's advocate and record. Yes, yes. Sir.
Same.
No, no, because he is not here.
Other private industries, one advocate on it.
Yes.
In fact, Sharma is, my lord, there for all three. Unfortunately, my lord, we are only for one.
I'm appearing only for one, Malat. For the
Para 57, 58, 108, 120, 121, and 125.
Yes.
The first is, my lord, there has to be, my lord, satisfaction under Rule 7.1. And, my lord, Rule 7.2 is mandatory. Kindly take, my lord, 42, para 42. Page, my lord, 17. On Lordship has that, my lord? Page 17. These numbers are. Para 42.
Yes.
On reading the provisions of Rule 7, Sub-Rule 1, 2, and 3, it is discernible that all such information that may be provided by the domestic industry under Rule 5.1 does not become confidential information straight away, merely because the provisions of 7.1 have been invoked. Rule 7.1 is not a declaratory provision so as to provide that all such information provided in the application under Rule 5.1 by domestic industry are confidential. Rule 7.1 is an enabling provision whereby any of the parties to the investigation, not merely confining to be domestic industry, making application under Rule 5.1 to make a claim that any or all the information provided by to the designated authority be treated as confidential. In the event the designated authority with regard to any such information or part thereof provided to it by domestic industry or any other party is satisfied as to its confidentiality, such information be treated by the designated authority to be confidential information. But a condition precedent to treat any such information or part thereof as confidential is that the designated authority is mandatorily required to arrive at its satisfaction that the information or part thereof is confidential. In the absence of any such satisfaction by designated authority, it cannot be construed that merely by referring to the provisions of so-and-so, the information contained in the application made under so-and-so be confidential. B, again, it also has to be understood that the satisfaction arrived at by the designated authority would also have to be a part of the record of the process of the investigation. And I'm on 7th February, it's totally absent. Further, Rule 7.2 provides that the party requesting for confidentiality is required to furnish a non-confidential summary thereof, where Rule 7.3 provides that notwithstanding the requirement of furnishing a non-confidential summary, if the designated authority is satisfied that request for confidentiality is not warranted or supplier of information is either unwilling to make information public or to authorize its disclosures in a generalized or summary form. Such information over which confidentiality is requested is to be disregarded. It is a clear provision of Rule 7 of ADR 1995 read as a whole that the party requesting confidentiality either satisfies the designated authority as regards the claim for confidentiality, for which the designated authority would be required to record its satisfaction. If such satisfaction is not arrived at by the designated authority, the information over which request for confidentiality was made would not be treated to be confidential. On the other hand, if the designated authority arrives at a satisfaction as regards the acceptance of the claim for the supplier of the information would be required to provide a non-confidential summary in a generalized or a summary form of such information which had been accepted to be confidential. In the event of either of the two requirements being not satisfied, either the designated authority was not satisfied with the claim for confidentiality, or the supplier of the information is either unwilling to make the information public or unwilling to authorize the disclosure of information in a generalized or summary form. Such information over which the request for confidentiality was made is to be discarded and not be taken into consideration in arriving at any finding in the course of investigation. Now, my lord, kindly take para 57. My lord, this is on what is essential information, which is page 22. The requirement of Rule 16 for disclosure of the information in our view is also in conformity with the principles of natural justice, as the imposition of the ADD has a direct consequence upon the interested parties who are also the importers of the dumped article. A disclosure of the information of the essential facts under consideration, which formed, kindly note this, which formed the basis of the decision of the designated authority, gives the interested party an opportunity to present their view if any such essential facts were taken into consideration, were otherwise ought not to have been taken under the law or in the facts and circumstances of the case, or such essential facts taken into consideration were factually incorrect. We have taken note of that in the procedure adopted in the instant case, although the designated authority had given an opportunity, etc., but neither the essential facts taken into consideration form the basis of the decision of designated authority, nor the normal value, export price, margin, as well as determination of the injury to domestic industry and non-injurious price were provided to the interested parties, importers, prior to such opportunity of hearing being given. These are all treated, my lord, as, my lord, essential facts. And then, my lord, kindly come to para 108. My lord, page 54. From the, my lord, after, my lord, all the decisions, my lord, are considered. From the aforesaid propositions, it can be culled out that under the following circumstances, a writ petition would also be maintainable, even though there may be a statutory provision for an alternative remedy, either in the form of appeal or revision. That's one, when the High Court has entertained an application and has heard the matter on merits, it would not be justified to dismiss the petition as being not maintainable. When there is a breach of the principles of natural justice, or where the decision arrived at is contrary to all accepted principles of justice, the superior court, in spite of the availability of an alternative provision for appeal or revision, can and must interfere, and such interference can still be made in favor of the petitioner who had allowed the time to appeal to expire or had not perfected his appeal by not furnishing so and so. Then, my lord, jurisdiction, etc. And then lastly, para 120.
That is Rido and Arend's case. Income tax.
Correct.
Matter 71.
Yes.
Supreme Court 33.
Yes.
That is income, that there was a different, there was time to file the revision or the appeal had expired.
Yes.
Though on this, our court has taken a little different view. Justice Justice Vishwas has passed a judgment.
Justice joined the wishes.
And a final hearing also, that is not the only ground.
In fact, in that case, the plea of maintainability had been reserved.
Yes, yes.
That had been reserved and it was taken in the affidavit also. Now kindly have a look at para 119. At page 58. From the provisions of Rule 7 as a whole, it will be difficult to accept the stand taken by the designated authority that even the normal value, export price, margin of dumping, and the non-injurious prices determined would be confidential, as because the same are based upon information provided by the intervener, who is the domestic industry, and therefore it cannot be disclosed, even to the extent that it cannot be disclosed to the court. Then, Miller, we also arrive at such a conclusion as because no material has been produced by the respondent authority that the designated authority had arrived at a satisfaction upon a claim for confidentiality being made by the domestic industry, that the entire information provided in their application are confidential. It has also not been brought on record that upon such satisfaction as regards confidentiality, the domestic industry was required to submit a non-confidential summary of the confidential information. It had further not been brought on record that the supplier of the information is either unwilling to make the information public or to authorize its disclosure in a generalized or summary form. In the circumstances, under the provisions of Rule 7.3, either the information provided is to be disregarded or they are to be provided in the manner as indicated in so on. Further, when we look to the provisions of Rule 16, we find designated authority shall, before giving its final findings, inform all interested parties of the essential facts under consideration which form the basis for its decision. The decision referred under our Rule 16 would have to be understood to be the decision in the final findings to impose ADD and the rates thereof. The essential facts under consideration for arriving at the decision to impose so-and-so and the rates thereof would have to be understood to be the normal value, export price, margin of dumping, and the non-injurious price of so-and-so. Then 125, in the instant case, accordingly, page 60, in the instant case, accordingly as the normal value, export price, margin of dumping, and the non-injurious price as determined by the designated authority, which form the basis for the decision to impose the ADD and determine the rates thereof, were not informed to the petitioner prior to the opportunity of hearing being given, we are of the view that in the instant case, principles of natural justice. And my lord, here your lordship seen that domestic industry manufactured and sold titanium ructile, my lord, sulfate titanium dioxide. It's no case of substitute. Said we directly manufacture this and supply it to domestic industry. It's the basis of, my lord, the decision. The last deal karo. First, let's do it this.
Will your lordships excuse me for today, Malad? I have a engagement, Malad. I'm so sorry I could not inform your lordships yesterday. I'm so sorry, Malad.
Mr. Sharma, are you available on 17th?
17th I can be available. But Malad, tomorrow, if your lordships give me 15 minutes, I'll be able to conclude.
17th, because tomorrow, you see, the difficulty is I have assigned those matters. I can't take these matters every day. So there are other matters.
Maybe from 4:15 to 4:30, Malad.
Tomorrow there's a full court reference, Mr. Sharma.
Tomorrow,
Oh, very well. Very well. Very well.
even within that short span, it will be not.
That's true. It will be unfair also, Manoj. I understand.
So I have to rise.
It's a
by
full
3
court
minutes.
reference,
So
my lord. So, my lord.
if I start also at
You're
2:30, it will not be
No way.
possible. Mr. Mitro might want to add something,
Correct.
whatever. You come on
Very
17.
17. Very well.
So
I'm so great.
I'll indicate to him.
Very well. Very well.
But now, my lord, I wish to deal with the cases, both on, my lord, which have been cited, my lord, on jurisdiction, on, my lord.
Just before that, on factual aspect,
Yes.
the product under consideration, PUC, is not rutile. It's a
Titanium dioxide. Yes, yes.
The entire product under consideration
Correct.
is different.
Yes.
It's not limited to rutile. What you
No,
have
but,
said.
my lord, those both are included, sulfide and, my lord.
Whatever is under that is included.
Correct. That's important because paint only uses sulfide.
But it is one and the same thing.
No, 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 no,
According
no,
to
not
Mr.
at
Sharma,
all. My lord, it's a
product under
different.
consideration.
No,
is
no,
different.
no, no, not at all.
That is what Mr. Sharma
No,
had.
absolutely wrong. I'll deal with that. Then I won't finish.
No,
Then I won't even finish today. My lord, I won't
you have
finish
to
today.
answer that because that point has been raised by Mr. Sharma.
My lord, kindly have a look, my lord. Then my lord, ছেড়ে দাও, এগুলো ছেড়ে দাও, পুরো order এ চলো।
No, you have to, this part you have
My lord,
to
I
explain.
showed it to your lordship on day one.
No, after Mr. Sharma indicated.
No, no, so I'll deal with it, my
Yes,
lord,
please.
with your lordship. I'm not saying I won't deal with it,
Because
but
it
I
is
came
this
with a high hope of finishing. I won't finish today.
No,
So, my lord,
you can still conclude it.
no, 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 my lord, I am human. I have not sat down from 10:30. My lord, I've come away from a division bench to argue before your lordship. I made them rise. So, my lord, kindly now, my lord, I was rushing it. Now, my lord, I'll take my time. So that I do justice, my lord, to my client.
Mukherjee, I have never
No,
stopped.
my lord, it's important.
Because
Your lordship has
get
indicated.
the clarification, Mr.
No, no, my lord, I can
I
only.
cannot decide it.
No, 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 no. My lord, your lordship, my lord, I'm not saying your lordship decided it, but my lord, kindly, my lord, now, my lord, cholo, mamla cholo. Yes. My lord, kindly take, my lord, page 56.
Yes.
The initiation, my lord, notification. এগুলো বাড়িতে নাকে তেল দিয়ে ঘুমিয়ে থাকবে আর
Yes.
Now, my lord, kindly come to the initiation, my lord, of, my lord, kindly see the heading. My lord, 28th March 2024, page, my lord, 55. ও যতগুলো প্যারা দেখিয়েছে আগে সেগুলো দেখাও তারপরে। My lord, kindly see the subject.
Yes.
Initiation of an anti-dumping investigation concerning imports of titanium dioxide originating in or exported from China. Lordship has that? Now, my lord, your lordship would also consider my case that I said exclude this category.
Yes.
So I need that. They have not excluded it. Anti-dumping duty, my lord, covers titanium oxide, every kind of titanium dioxide, whether it has a crystal structure or not, anything they call titanium dioxide. Now, my lord, I say exclude this. That's what's been shown to your lordship.
Yes.
Now, my lord, they say no, there's no question of exclusion. Because what you are asking for exclusion is manufactured here, sold to the domestic.
That is their answer. But apart from that, Mr. Sharma indicated that, look, what was the product under
Absolutely, my lord. I have a case for exclusion. The designated authority will decide whether anything is to be excluded or not. My lord, what was my representation? Please exclude this.
The difference between the entire titanium dioxide and
Big
product.
difference. I'll show your lordship.
Yes, just
The
indicate.
order. No, no, my lord, I'll read it, my lord, so that,
Yes.
my lord, we all understand it,
Yes.
including, my lord, my learned friend, Mr. Sharma, who's left. Now, my lord, kindly come to product under consideration, A. Kindly have a look. Tell me what all he's placed and not placed. The product under consideration in the present application is titanium dioxide, excluding what? Food, pharma, skincare, textile and fiber application, and nano or ultrafine titanium dioxide having particle size below 100 mm. Specific exclusions from the scope of the product. So, my lord, this is the initiation of the inquiry.
Yes.
So, my lord, it's anything that is known as titanium dioxide, excluding for, my lord, these fields. Now, my lord, specifically excluded from the scope of the product under consideration are titanium dioxide meant for following applications. Now, my lord, let us read, my lord, this to understand what is the difference. General properties of the product. Not placed. Kindly mark this. He has not placed it. My lord, this is what I have placed. And he must answer this. Titanium dioxide is a white inorganic compound extracted mainly from mineral ores and is used in a vast number of diverse products. The principal natural source of titanium dioxide is mined ilmenite ore, which contain 30 to 60% of titanium dioxide. It's, my lord, like our iron ores. My lord, when, my lord, they are mined, my lord, iron content can be 60%. My lord, others are impurities. So similarly, it's saying, my lord, form, my lord, ilmenite ore, my lord, the impurities can be, my lord, up to 70 to 40%. Pure titanium dioxide is produced from ilmenite ore either using chloride
or the sulfate process.
So, my lord, there is a chloride process and there is a sulfate process to get pure titanium dioxide. The subject good in the present investigation, that is titanium dioxide, are pigments. Now, my lord, this is very important. Titanium dioxide can be broadly classified into pigmentary titanium dioxide and nano ultrafine titanium dioxide based on its particle size. Pigmentary titanium dioxide is approximately 200 to 350 millimeter in dimension, which forms 98% of the total production and is used mainly for its high refractory index and consequent scattering of visible light and high opacity. In other words, 98% of the global production of titanium dioxide is used as a pigment.
Yes. This next one you showed me, grades of titanium dioxide.
I'm showing, I'm correct, absolutely.
This
Absolutely. Then, my lord, I'll show what our stand was. Grades of titanium dioxide, rutile and anatase grades. The petitioner's applicants are manufacturing rutile and anatase grades of titanium dioxide, which are two forms, kindly mark this, which are two forms of titanium dioxide depending on what? The crystal structure. Rutile is a mineral composed primarily of titanium dioxide. Rutile is produced from ilmenite, which is a mixture of titanium, ferrous iron, and ferric iron. Rutile is the most common natural form of titanium dioxide. Rutile has among the highest refractive indices of any known mineral and exhibits high dispersion. Natural rutile may contain up to 10% iron and significant amounts of niobium and tantalum. Now, Millard, this is rutile. Now we come to anatase. Anatase grade of titanium dioxide is produced from ilmenite, which is a mixture of titanium, ferrous iron, and ferric iron. So, my lord, your lordship sees, my lord, the difference. My lord, earlier it's titanium, rutile, my lord, is, my lord, mixture of titanium, ferrous iron, ferric iron. Here also it's the same.
Yes.
It has a very high degree of whiteness, anatase. Titanium in ilmenite is extracted by reacting this raw material with sulfuric acid. Kindly one. Titanium goes into the solution as titanium oxysulfate. Titanium dioxide anatase is obtained from titanium oxysulfate by injecting live steam and dewatering the treated pulp. Uses. Titanium.
This is the difference.
Yes. One of the
Process,
different.
process.
Yes, my lord, more. I'm going to show more.
Yes.
Titanium dioxide is the brightest and whitest of the known pigments and is the most sought white pigment in application such as paints and coatings, plastics, papers, rubbers, and inks on account of its high refractive index and ultraviolet resistance. The high reflective index imparts high whiteness and hiding power to the end products. Titanium dioxide pigment also finds application as energy server as it reduces need of air conditioning because of light reflecting qualities when used in paint coatings on the outside of buildings in warm climates. Now the tariff clarification. The product under consideration can be classified under chapter 28 and 32. The dedicated code for the product under chapter 28 is so and so. However, since it is a pigment, imports are also being reported under so and so. However, it is possible that the subject goods may be imported under other headings, and therefore the custom classifications are indicative only and not binding on the scope of the present investigation. The parties in the present investigation, now kindly note this, this is the most important. The parties in the present investigation may provide their comments on the PUC and propose PCNs, if any, within 15 days of the circulation of the non-confidential version of documents filed before the authority. So, my lord, the investigation starts for everything, which is called titanium dioxide, with specific exclusions for in its application for certain products.
Proposed PCNs means? Proposed for exclusion.
Yes, product control numbers and proposed product control numbers. My lord, now my lord, product control numbers, my lord, are product characteristics. You can't sit here.
Yes.
My lord, now, yes, B, my lord, like article. The applicants have claimed that the subject goods which have been alleged to be dumped in India are identical to the goods produced by the domestic industry. That's their claim, that what you are importing is identical to what is being produced and sold here. Then, there are no known differences in the technical specifications, quality, functions, and end use of the two products. The authority notes that the two are prima facie technically and commercially substitutable. Therefore, for the purpose of the present investigation, the subject goods produced by the applicants in India are being treated as like article to the subject goods being imported from the subject country. Then subject, my lord, is, my lord, China, domestic industry, and then basis of alleged dumping, etc. Now, my lord, kindly come to, my lord, submission of information on, my lord, I've shown this, confidential basis. Where is the next one? Yes. My lord, now kindly come to page 59, my lord.
That point you have raised in page 60.
Yes, my lord, because the submission was, we've not challenged the PUC at all. Now, my lord, and according to my learned friend, my lord, it had again fine. That's what I'm showing your lordship, my lord.
That is there. That I have seen. I wanted the clarification on the product.
Yes.
That is, what is the difference of the product?
Yes. Now, my lord, I am, my lord, deal with that definition at page 60.
Yes.
Then, my lord, yes, my lord, first is 61. After that, extraction, I say it's emphasized that PUC described in initiation is expensive. It includes certain grades which the domestic industry does not manufacture. These distinct grades deviate in what? Technical characteristics, consumer perceptions, and end applications usage from the other grades sold by D1, DI. Hence, it is humbly requested that scope of PUC should exclude such grades. Subsequent paragraphs expound upon these contention. Now, my lord, what do I do? My lord, first thing I do is refer to, my lord, the anti-dumping agreement. And my lord, I go down, my lord, now kindly come to 62. My lord, kindly see paragraph 3.35. My lord, of the manual reiterates certain factors considered by Indian courts in determining like articles as follows. Certain other factors which have been considered relevant by different tribunals are as follows. Commercial substitutability and, my lord, kindly note, manufacturing process, uses, raw material and properties of the product. The resemblance in terms of properties, even though there were substantial impurities in the domestically produced like product. If the product is easily convertible, and such a fact is also recognized by exporters. The difference in raw materials has not been considered decisive if the products are commercially technically, then perception of consumer. The PUC, as defined currently, encompasses both the grades produced and marketed by DI and grades imported that are not domestically manufactured available. These specifically specialty grade exhibits distinct technical and commercial characteristics in terms of physical characteristics, application and end use, consumer perception, which makes them commercially non-suitable with the grades produced by the domestic industry. Consequently, the grades not manufactured by DI do not qualify as a like product or a like article under Rule 2D. Then, my lord, in this context, we request the following for exclusion. My lord, kindly have a look at, my lord, C at page 65. I've given several, my lord, physical, chemical, etc. But now this is very important. Sulfate grades, page 65. For the decorative paint segment, the DI's product is unsuitable for achieving a medium to high quality finish and is used by members for base coats only for primers. We emphasize and reiterate that sales within the paint sector heavily rely on visual allure as perceived by consumers and is the main factor which affects consumer. Thus, differentiation between grades must primarily hinge on the appearance and external finish of painted. In this context, following attributes set apart the imported and domestic products. Well, 3 bases we've given. In view of the above, it is respectfully submitted that given the difference in physical and chemical properties, end usage and consumer possession based on so and so, the domestic industry's product cannot be considered as like product under Rule 2D. Now, my lord, B is very important. Kindly have a look at it. Clause B. The domestic industry has not proposed a product control number methodology in this investigation. Accordingly, the Honorable Designated Authority has requested proposal for PCN methods in its initiation notification dated so and so. We understand that there are significant differences amongst the various grades of PCN. Thus, to achieve the objective of an apple-to-apple comparison, which is facilitated by a detailed product control number method, we propose the following PCN table. My lord, first is on application, then my lord is on crystal structure, then on particle size, then my lord production process. Your lordship had pointed out production process. This is my lord product control. These are the features we trust that the above PCN method would be considered for the purpose of better comparison between. Then, my lord, My lord, page 77. Now kindly have a look. My lord, the DGTR, my lord, had certain queries. Page 77, we wrote 7 June 2024. My lord, kindly come to 78.
Yes.
My lord, second paragraph. The respondent has sought the exclusion of variant bright and bluish undertone rutile performance grade so and so. It also proposed the issuance of a PCN methodology. The reasons for exclusion of the above mentioned grades as well as suggested PCN have been submitted before the Honorable DA. Same are being relied upon and not being repeated for the sake of it. In order to examine the veracity of product exclusion requests made by respondent, certain questions were posed by so and so during the oral hearing. Question and responses are provided below for necessary perusal and examination. Now, my lord, kindly come to page 82. My lord, all this goes on. My lord, question 6.
Yes.
My lord, for BLR 698, Rs 868 or BLR so and so, provide quantifiable data demonstrating comparative differences between domestic grade that was tested vis-a-vis the imported grade. So, my lord, all this while, my lord, it's sulfate which we are importing, my lord, is being tested against, my lord, chloride or anatase. They wanted, my lord, we are not told that why is this necessary? It's already happening. Domestic industry is manufacturing sulfate grade. Now, my lord, they ask, this is the query which we respond to. Are sulfate-based rutile grades and there are no suitable comparable sulfate-based rutile grades available with DI. This is because the DI does not possess the manufacturing setup for producing sulfate-based rutile grades. Accordingly, no comparative analysis. Given the absence of a domestic substitute, should be excluded from the scope of PUC. So they are finding where they say that this is being done. Where else is there? Before 319.
Yes.
$167 next. Which goes next? My lord, kindly see the date, my lord, of this.
Letter?
Yes, my lord. It is, my lord. Yes, 7th of June. Now, my lord, kindly come to November 8 at page, my lord, at page 89, volume 2, my lord. No, no, my lord, this is, my lord, dated, my lord, 8th of November 2024, 89, middle of the page, your lordship will find.
Yes.
Now, my lord, kindly look at the table of contents. My lord, page 90. Scope of the product under consideration. Injury should be assessed separately for rutile and anatase as well as for rutile chloride and rutile sulfate to ensure an objective analysis. Now, my lord, page, my lord, 95. My lord, towards the bottom, exclusion for sulfate-based rutile. My lord, those BLR numbers, my lord, which I read, owing to lack of domestic capacity. Then, my lord, as acknowledged by the domestic industry in para 32 of its petition, rutile can be either used so and so. The sulfate process imparts a yellowish tone to PUC, whereas the chloride process imparts a bluish tone. Consequently, a comparative analysis so-and-so is impracticable. Notably, it's an accepted and known fact that sales in paint industry are often leverage based on visual appeal as perceived. For specific, the user industry requires PUC to be manufactured via designated either sulfate or chloride, depending on whether a yellowish or bluish tone. It is highlighted that if any paint formulation has been designed as per, it will give suboptimal properties with the chloride process, whether the latter is procured or from any other exporter. The DI lacks the necessary manufacturing setup to produce sulfate-based rutile, as the facilities are configured solely for chloride process. This process is inherently distinct from sulfate process and requires a complete separate specialized plant infrastructure, precluding any possibility of conversion or production of sulfate-based rutile. As such, it is underscored that imported sulfate-based rutile has no suitable comparable sulfate-based domestic for due to structural manufacturing, etc. Millard goes on Millard till Millard 97. Then Millard chloride process, what is manufactured? It's of poor quality. That is Millard also mentioned. Then Millard, kindly have a look. Millard, kindly come to page 147. Millard, kindly have a look at the date of this. It's a rejoinder. November 2024. Oh, I'm told, my lord, these are not being shown.
No. These were not shown.
And my lord, so my lord, PUC is not something which has been accepted as stated in the initiation. That's, my lord, the important point.
Very well.
My lord, page 150. Paragraph 4, 5, my lord. Then, my lord, para 153, page 153. This is, kindly see, my lord, how important this is. Third line. In arguendo, in case TIPL indeed manufactures rutile sulfate, it is highlighted that normal business conduct would be to offer its product for sale to Indian user. However, as per information received from member paint, DI has made no such. Instead, directly introduced its production and sales of rutile in an anti-dumping investigation without taking any steps to ensure that its products are available for commercial. Therefore, DI should disclose exact timelines of when it commenced production, if at all. And if rutile already, it is puzzling why it did not reach out to user industry offering grade. Thus, its conduct of not informing about availability is without business logic. Fact that DI has failed to engage in such this behavior requires DI's sole intention to seek duty without any genuine effort to supply, etc. Then, my lord, again, manufacturing process, etc. My lord, hold that. So, my lord, it's not that it was accepted, my lord, that is, my lord. And, my lord, no initiation of dumping, my lord, is, my lord, PUC, my lord, accepted. My lord, domestic consumers will always seek, my lord, any exclusion.
Very good.
Now, my lord,
You finish the point on the territorial jurisdiction today?
Yes, my lord, I'll do all of those, my lord, now. My lord, while I deal with the cases. My lord, there's a Madras High Court decision, my lord, exactly on what I'm told your lordship had indicated. My lord, that the disclosure statement, the final finding is pan-India. My lord, it's an initiation of a proceeding in REM, because it's inviting, my lord, everybody to come, my lord, and join in, whoever's interested. My lord,
Because that line, all parties interested here.
correct, absolutely.
Yes.
And my lord, it's in the official gazette. It's both are gazette publications. The final finding
As also the
as also the initiation
and the disclosure statement.
and the disclosure. My lord, disclosure, not the disclosure. My lord,
Final
the
finding
finding
and
and the, yes. Now, my lord, may I deal with the cases very quickly?
Yes.
My lord, first is, my lord, I shall, my lord, deal with.
But difficulties, they are not disclosing the.
So your lordship will take a call, my lord. This can't go on.
No, this can't go on. Then you produce the records. I think that will be better.
I'll ask them to present optimal problem.
With all the records, yes.
Your lord.
Whosoever is there.
He is suggesting my lord.
No, the records in relation to the only Rule 7, nothing more. Not orally. I want to see the documents. Any satisfaction
My
has
lord, your
been
lordship
reached or
can
not.
say Rule 7.
Yeah, I've already indicated in my previous order.
Yes, it's there.
Yes, and they said that, but yes.
Today I'll indicate whatever decision has been taken by you in relation to disclosure made by any of the parties.
I'll ask them to present.
Yeah, absolutely.
With all the files.
Same, lekha ache. My lord, the first decision I deal with, my lord, is, my lord,
By Mr. Sharma,
no, Mr. Sharma, my lord, is last.
Mr. Mitra.
My lord, no, my lord, the union, my lord, Mr.
I see.
Bhattacharya, my lord, kindly come to. My lord, whoever cited few, my lord, I'm doing them first. My lord, kindly take, my lord. Yes, my lord, it was handed up, my lord. I have a copy.
Muralidhar's judgment.
Yes, my lord. Sun City sheets, my lord, your lordship has that.
I have
2017.
2 copies. You wanted one? Yes.
I have a copy. No, that he made available. Otherwise, he'd have had a tough time.
Yes.
My lord, kindly see, my lord, 2017 SEC online, Delhi.
Yes.
Now, my lord, this was, my lord, a writ petition. My lord, challenging, my lord, a notification issued by designated authority publishing the final finding, recommending levy. Then, my lord, kindly see at the outset, a query was posed to Akhil Sibbal for the petitioner as to why this court should exercise its discretionary. The query was in the context of following 2 factors. The final finding is yet to be accepted by central government and a notification implementing, therefore petition is premature. Even if such a notification was issued by central government, petitioner at that stage has a statutory remedy. Then, my lord, the submission is, Mr. Submil submitted that there was non-compliance by DA of specific direction issued by this court in the order dated which challenged the notification, which has resulted in the final finding. He pointed out that in the said order, court has directed DA to take into consideration on, according to him, DA has failed to pass on each of the. Mr. Sibbal, was unable to dispute that this very contention. So para 4, my lord, I'm relying on to show there was a concession. That this very contention that DA had not complied with directions can be urged by the petitioner as and when it challenges the final finding and the consequent notification. Mr. Sibbal then submitted that this court should interfere since petition involves violation of principles of life. What that violation was, we don't know. However, he could not dispute that even this ground can be urged. So, my lord, it's, my lord, complete surrender.
You have already explained.
Yes. So, my lord, this old law, my lord, no longer there. Second, my lord, it's on concession. Now, my lord, sorry.
Yes.
Now, my lord, the second decision I'm distinguishing, my lord, is ExxonMobil Asia Pacific versus Union of India. My lord, it's a division bench judgment of the Delhi High Court. My lord, unreported, my lord, which was handed up by the union as well as, my lord, Mr. Sharma. My lord, again, my lord, this is, my lord, pre-amendment. Yes, it's post-amendment, correct. But it did not consider, I'm grateful to my learned friend. My lord, it's post-amendment. But based on, my lord, pre-amendment judgments. My lord, paragraph 8, your lordship will find.
The points raised by you
No, not there at
have
all.
not been considered.
No,
at
not
all.
there at all. And my lord, in terms of 9C, once the decision, if the same is not, then the challenge could be by respondent number 3, so and so. And my lord, it's as if the notification can be challenged, my lord, before my lord.
That's the central government stand that it cannot be challenged.
And my lord,
Your
and
stand that
yes, and in spite of that, this case is cited. Yes. My lord, the next case, my lord, is Jindal Polyfill. The old lordship. My lord, I dealt with this case before. My lord, it is again the old law, my lord. Then, my lord, two cases, my lord, have been cited by my lord Mr. Mitro. My lord, one is Union of India versus Pradip Kumar De. That's 2008 SCC.
no. Jindal Saw Limited.
My lord, that's different.
You will later. Very well. Come.
That's different. My lord, I was referring to your lordship to
Mr. Mitro is Pradip Kumar Mitro is
Jindal
yes.
Polyfill. My lord, what I, my lord, dealt with was Jindal Polyfill.
Yes, yes.
Now, my lord, kindly come to.
We have also relied on this charge.
Coming,
Yes, yes.
all. My lord, I'm doing it in batches.
Yes, yes.
So that,
whichever it is.
my lord, 2000 volume 8 SCC.
That is Pradip Kumar De.
Yes, Pradip Kumar De.
Yes.
Now, my
Paragraph
lord,
7 and yes.
yes. Now, my lord, the most important thing is, my lord, it's the recommendation per se in this case was not by the pay commission, but my lord, the directorate of CRPF. Lordship will find that at from my lord, paragraph 6 to 8. My lord, it was a recommendation made to the pay commission, number one. Second, my lord, it is not a statutory recommendation which is actionable. Even all statutory recommendations are not actionable. But my lord, this statutory this is not even, my lord, actionable. My lord, in our case, the amended provisions and, my lord, the WTO, my lord, agreement, my lord, the GATT agreement, my lord, recognizes that, my lord, it is actionable, the final determination. So, my lord, there's no question of, my lord, this case, my lord, having any application. And, my lord, usual distinction, my lord, that it is not an anti-dumping case at all. Where, my lord, the final determination is actionable. Final finding. Now, my lord, similarly, my lord, 2022, 10 SCC, 700. My lord, that is, my lord, the GST Council case, my lord, Mohit Minerals.
Yes.
Now, my lord, here again, My lord, the determination of the GST Council, my lord, is not recognized, my lord, as being actionable under statute. Same distinction, my lord. Now, my lord, I'll deal, my lord, date-wise of, my lord, the cases, my lord, which have been cited, my lord, on jurisdiction.
Yes.
My lord, 1985, 3 SCC, my lord, Swaika Properties, my lord.
Yes.
The first case, 1985, 3 Supreme Court cases, 217. My lord, here, my lord, it was, my lord, land acquisition. Notification itself became effective in Rajasthan because the acquisition is happening in Rajasthan, not, my lord, anywhere else.
Yes.
So, my lord, paragraph 8, my lord, your lordship will find it is, my lord, not applicable at all. My lord, in our case, the effect of the final finding is, my lord, all over India. And, my lord, commenced on the basis of an initiation notification, which is also, my lord, pan-India. And it's concerned, my lord, with imports, which happen all over India. We can have air imports, we can have, my lord, vessel, we can have car, vehicular. And we can have, my lord, vessels, as I said. So, my lord, it's every nook and cranny, my lord, which has, my lord, my lord, cargo unloading terminal. Yes. Then, my lord, 1994, 4 Supreme Court cases, 711. My lord, this was used to be, my lord, your lordship might recall, my lord, a favorite case, my lord, for tender matters. My lord, where, my lord, the tender, my lord, clauses, my lord, that is, my lord, ONGC versus Utpal Kumar Basu. My lord, 1994, 4 SCC, 711. My lord, jurisdiction was invoked on the basis that the advertisement was read in Kolkata. Then, my lord, Kusum Ingots. My lord,
Same lines.
ONGC case and Swaika, my lord, were considered here.
Paragraph 12.
Here, my lord, kindly have a look at para 21.
Yes.
My lord, I rely on the last 2 sentences because, my lord, the act, my lord, has been implemented and implemented pan-India with the final finding, and before that through initiation. Para 21, my lord. It is not so done because a cause of action will arise only when the provisions of the act or some of them which were implemented shall give rise to civil or evil consequences to the petitioner. My lord, here it's happened. My lord, I have shown, my lord, I have my registered office here. My constituents, majority of them have their registered office here. Like Berger Paints. My lord, Kolkata is a port. 2 ports we have, import. Airport also we have. We have the state, my lord, has, my lord, my lord, huge, my lord, territorial, my lord.
Border is also there.
Yes, that's what I'm saying. Land border is also there. And my lord, this is, my lord, totally, my lord, different case. Again, my lord, not concerned with notifications having pan-India force under a statute. And notifications issued pursuant to, my lord, a legislative exercise. My lord, then, my lord, 2021, 20 Supreme Court cases 267. My lord, Union of India versus A. China Mall. My lord, again, my lord, service matter.
Para 46.
Yes, my lord. Para 46 is wholly irrelevant. It doesn't deal with jurisdiction at all. My lord, para 49 and 50. And your lordship's aware, my lord, that in, my lord, Union of India versus Alapon Bandopadhyay's case, my lord, the court went on to hold, my lord, the Supreme Court, that, my lord, as far as Central Administrative Tribunal is concerned, my lord, it is where that tribunal is. It's a restriction, my lord. We've discussed it as a wrong judgment. But, my lord, in any event, this is a service matter. The point was here where the notice is effective.
Yes.
Now, my lord, this is the one. জিন্দালটাও দেওয়া আরেকটা বললো জিন্দাল না না আছে একটা জিন্দাল my lord, your lordships, there was another jindal. There is এই তোমরা দুটো two jindals.
Yes, which one you were relying?
My lord, your lordship said there were two jindals.
This Jindal Saw Limited. On the first day it was cited.
First day, my lord, I had dealt with it, my lord, on, my lord, the Gujarat, my lord. They were seeking to deal with, my lord, the Gujarat. My lord, we had shown, my lord, the High Court order.
But you have to also, yes.
My lord, here, my lord,
Which order?
my lord, my lord, SLP order was shown, my lord, regarding, my lord, the Gujarat High Court.
Yes, yes, yes.
My lord, that is the, my lord,
এই আরেকটা কপি গেল কোথায়? ওই আরেকটা এসএলপি এটা কপি ছিল অর্ডার ছিল।
my lord, we had, when dealing with that, my lord, we had cited. We had already cited, my lord.
Just a minute, let me find it out. It's not there in the compilation. No, so I got these. Not there. Give me just once print out of that anyone.
My lord, they had
just mail it to my court.
My lord, yes, my lord, we had, I'll give your lordship the reference.
Yes, yes.
2019 SCC Online Gujarat 1980.
ছিল হ্যাঁ দেখতে পাচ্ছি না 19
My lord, we have an extra copy, my lord, if your lordships want.
it must be recorded here also.
My lord, I had relied on two Gujarat High Court orders. In fact, one, my lord, to deal with that, my lord, they, my lord,
Yes, yes.
my lord, the first Gujarat High Court I had relied on, that a writ petition lies both against disclosure statement and the final findings. My lord, is reported in 2017 SCC Online Gujarat 2526.
Yes.
My lord, I relied on para 129, 151, 154 to 155. My lord, they, my lord, came and said there's a Supreme Court, my lord, from, my lord, another matter, not this matter, my lord, from Gujarat High Court, and relied on Jindal, my lord,
Jindal Saw Limited.
Saw Limited, the SLP order.
Yes.
In our opinion, it was ill-advised for the High Court to entertain in such a matter when the order is appellable under 9C. And this, my lord, your lordship will find is prior to, my lord, the amendment.
5th April 2019.
Yes. Now, my lord, in response to that, we showed your lordship, my lord, what, my lord, the matter was. My lord, 2019 SCC Online Gujarat 9. Yes. My lord, there are two Gujarats. One is Nirma, which is 2017.
It's you are at 2019 369 ELT 507 Gujarat.
Yes, correct.
That is the one.
Yes, I cited that, but my main judgment was Nirma, which is, my lord, 2017 SCC Online Gujarat 2526.
Nirma. Yes. 129 to 151.
Correct,
Yes.
correct.
But you also showed me this judgment as well.
My lord, I had cited two others. My lord, S.N. Mukherjee.
Yes, yes. Those are there.
And Whirlpool, my lord, I had cited.
That is
Now, my lord, I come to, my lord, one case which has been relied on, my lord, by, my lord, Mr. Mitro, my lord, which is Autocompu Stainless versus Union of India. Now, my lord, one minute. এগুলো consider করছে, এটাও consider করছে। না, cited না।
Sure. Okay. Yes.
Now, my lord, this case was relied on, my lord, to, my lord, submit that because, my lord, one of the averments which we have made in the writ petition, para 27.
27, yes.
My lord,
That you
para
are likely to suffer.
Yes, they say, my lord, that they are unapprehended. You
Totally
cannot have
apprehended.
cause of action. I want to show your lordship, my lord, in this kind of a matter where, my lord, initiation, my lord, in an anti-dumping and a later decision of Madras High Court where all these cases were cited, court said you have jurisdiction. I want to show your lordship that. My lord, Autocompu was relied on. Now, my lord, subsequent to that is, my lord, 2012 SCC Online Madras. No? Thank you. Wherever it's marked. আমারটাতে marked আছে। নেই? এই তো। না, এখানে। This is theirs. না, না, এগুলো সব এটা উপরে আছে। Yes.
This is 2012.
Yes. My lord, theirs is also same time, my lord. But this is theirs has been cited. My lord, Autocompo cited in this case.
I see. This was decided on 30th November 2012.
Yes.
I see. Now, Autocompo is on 10th of July 12.
Yes.
Yes, yes.
My lord, para 16, if your lordship sees, para 16. In fact, my lord, if your lordship starts, my lord, from my lord, paragraph 13, lordship will find, my lord, all the cases cited here, my lord, have been cited, my lord, in before the Madras High Court. My lord, Kusum Ingots, Alchemist, ONGC versus Utpal Kumar Basu, and Autocompo, para 13 to 16, lordship will find all are. But my lord, I want to place, my lord, certain facts to show, my lord, yes, my lord, kindly take, my lord, para 2. The writ petition and W so and so has been filed to call for and quash. Kindly see, my lord, para 2. To quash the disclosure statement of the first respondent issued under so and so, hereinafter referred to as the rules, originating or in Thailand and United Arabs. It has engaged in the business of so and so, has been importing subject goods. Located subject goods have to be cleared from bonded warehouse and as per provisions on payment of so and so. Now, my lord, kindly come to para 19. My lord, the preliminary objection on jurisdiction which I showed, my lord, goes on to para 18. 13 to 16 has all these cases. Then para 19. Mr. P.S. Raman, learned counsel appearing on behalf of the petitioner, has submitted that this court would have the necessary jurisdiction to hear and dispose of the writ petition filed by the petitioner under so and so. He has submitted that this court would have territory as per Article 226. Further, kindly note this, further disclosure statement issued by designated authority and final findings to be issued by the said authority would have statutory force and they would be binding on all the interested person concerned, even though they may be at different places in India. Petitioner company has its registered office at so and so in the state of Tamil Nadu, and import of subject goods are made through Chennai and Tuticorin ports. He has relied on the decision of so and so in support of his contention. It has been further submitted that proceedings of designated authority who is at New Delhi would apply to all parties concerned throughout the territory of India. It has also been stated that the court had passed an order in so and so to consider preliminary objections, etc. Then, my lord, kindly go 5 lines after that, sentence starting 6 lines from the start of that page. The learned counsel has also relied on the Supreme Court reported in so and so to state that bundle of facts which would constitute cause of action should be looked at, while accordingly the court would have jurisdiction to hear and dispose of the matter on merits in accordance. Even if a part of cause of action arises within territorial, be sufficient for this court to entertain. Similar submissions have been made by learned counsel, etc. Now, my lord, kindly come to para 33. In view of averments made as well as the respondent and view of submissions made by learned counsel and on a perusal of the relevant records available and considering the decision, this court was of a considered view that the petitioners have shown that there is sufficient cause of action to entertain the writ petition. Then petitioner carrying on business operations having in the state of Tamil Nadu, and certain imports of subject goods are being made through Chennai and Tuticorin ports, so and so have also been levied on provisional duty by authorities. That's the third ground. As such, it can be held that at least a part of cause of action is found. So, my lord, location of business. Because it's pan-India, my lord, it has statutory force, my lord, all over. And we have stated, my lord, that we import, my lord, these products, my lord, through, my lord, ports, my lord, in, my lord, India. The second bit, my lord, 34, my lord, was held against us, my lord, saying it's premature. Because the old interpretation was being applied. But otherwise, cause of action, my lord, was within jurisdiction. Now, my lord, your lordship wanted, my lord, the Richard.
The division bench judgment you indicated that you will submit.
Yes, my lord. I find with a division bench, sir. My lord, kindly state, my lord, Bagadia brothers.
Also, that's very good. And brought the judgment of Justice Doctor as well.
No, but that's a 4-page, my lord, four line judgment. My lord, what had happened? My lord, in fact, do you have the 226 rules? My lord, a division for administrative purposes, my lord, cannot, my lord, denude the jurist, my lord, denude, my lord, the jury. In fact, my lord, I don't know if the 226, my lord, rules are here. I can show your lordship. There is no direction, my lord, in those rules that it has to be filed, my lord, before. It can be entertained. My lord, if they are, my lord, the statutory authorities, my lord, outside jurisdiction, then appellate side can only entertain, an original side can't. My lord, is not the rule.
Paragraph 5, last part.
Yes, my lord.
Very well. They had not taken this point.
Yes.
That is all, Mr. Mukherjee?
Yes, my lord.
Yes,
I'm
Mr.
grateful,
Mishra?
my lord. My lord, may I have your lordship's leave?
This judgment I have not seen. Now, my lord, Mr. Mukherjee relied on this judgment of Vikash Trading Company versus anti-dumping and allied duties. This was relied by him today.
Here, my lord, what I find, my junior very lady, provisional duty was already levied. So there was actual financial. Paragraph 6, lordship, kindly come to now. Paragraph 6 of this judgment. It has been yes, lordship, kindly come to the 3rd, 6th, 7th, 8th, 9th line of paragraph 6. Thereafter, the designated authority had issued the preliminary findings by notification number so recommending the imposition of provisional anti-dumping duty on the import of the subject. In accordance with Rule 66, authority had provided another opportunity to all of them known parties to present their dues accordingly. And
so here, according to you, the cause of action was.
Lordship, can I see paragraph 33? My junior pointer, paragraph 33 is already been levied.
Yes, yes.
So it is no longer. Now, Lordship, they have. I'm told they have revised their case. Now they are saying only certiorari. So no loss suffered. It's for certiorari. I'm asking. If it's certiorari, then Rule 13 of the writ rules apply. 13 of the writ rules where the records are lying. Lordship kindly takes the writ rules. That's writ rules. Writ rules. That's it. Writ rules. So kindly takes a look at the writ rules. Writ rules necessary aberrament in a section.
Appellate side rules আছে তার মধ্যে আছে দেখো appellate side rules আছে এখানে আছে তার মধ্যে আছে প্রথমটা
Yes, Lordship kindly takes a look at the writ rules. Rule 13, if I am not mistaken.
Yes.
Rule 5. No, Rule 13 to
13.
So that is it is an application for a writ. Nature of session, there should be a statement. The location of the record of the proceeding. That is why, my lord, certiorari challenging an order. And lordship, certiorari like 227 has to be the tribunal has to be within jurisdiction. That is why the doctrine of merger does not always annihilate the trial court's order. That is why Kushum Ingot said, in a certiorari, when you are challenging an order of a quasi-judicial authority, it is either the first authority or the appellate authority, because that is the cited and lordship by juniors.
No, one more judgment.
And if he has shown any judgment contrary to that, certiorari can be filed. An order passed by National Company Law. That
add up more judgment.
No, he has not cited any judgment for the proposition that certiorari can be filed for a tribunal outside that tribunal's. Outside that court. I can't file a CAT order here in Madras. However much I may be aggrieved, because any order like there can't be 6 writ petitions of certiorari. One can file also 227 also. In different, one in Punjab, one importer there. 227 is same. It is the all other forums. It is 227. All other courts. In our code, it's why the 226 or 227. But the principle, so far as challenging 226 is concerned, territorial jurisdiction, unlike a mandamus where you suffer a loss, this here it has to be where the tribunal or the judicial authority is. So that's why my submission was, if this converted into a levy under Rule 18, then a cause of action for writ petition could have been filed if they could show that either loss or apprehended loss whenever I import my goods. But as of now, there is no such cause of action today. Today, it's as a pure quasi-judicial authority's order. As their argument was, this was the quasi-judicial finding, like Autocompu. If there was a provisional duty levy, yes, I'm suffering a loss. I can challenge that provisionally. But then if I am challenging a quasi-judicial authority's order, I have to go to the originally it used to be either one court. Now, after Kushum Ingots, it is either where the first quasi-judicial authorities or the appellate quasi-judicial. So writ petition cannot lie in our High Court. Wait for Rule 18. The levy is there. If they are to suffer the levy, then like a statute, they can challenge it. But
the rest of the argument is on the amendment and the effect of Rule 7 to that extent.
That too. Pragya Sharma can argue. That Mr. Sharma, I think.
Yes, he's still there.
He's still there. Tomorrow he's there. So he.
No, I can't take it up.
Whatever. That let him. On 17th, then he will argue on 17th. So far as jurisdiction is concerned,
he will not be there on 17th.
I don't think there's anything more on jurisdiction.
Very well.
Yes, I think there's no jurisdiction. No. There were extinguisher cases. Because they cannot be.
Very well.
No new
Sir,
judgment.
when will you file it? On the next date? Very well. I'm not recording anything today. Since you have sought for instruction, let it come. And if you want, I can direct the authorities to come to court.
I have already told them to come.
Yes. Yes.
With the necessary
Yes. I think that will be better. Because there appears to be some haze with regard to this aspect. Mr. Mukherjee, learned advocate representing the petitioner, and Mr. Mitra. Mr. Mukherjee, learned advocate representing the petitioner, and Mr. Mitra in response. Wisdom. Mr. Bhattacharya, learned advocate representing the Union of India, would submit that He's yet to receive the required instructions. Yet to receive the required instructions. Mr. List this matter for further consideration under the same heading on 17th. সাড়ে তিনটে বলেছি প্রথম বলেছি কিছু টাইম বলেছি কিছু বলিনি 17th আবার যদি সাড়ে তিনটে হয়ে যায় কোনো কারণে তো কেলেঙ্কারি হবে। Let it remain at 3:30. You see, I can't really fix it in anticipation of what is going to happen.
Not yes for indulgence like that. But you kindly allows him next day to distinguish the cash trading. And well, one more thing is not this matter, CSC matter. It's a Basu.
Yes, Mr. Vasu came in and said,
Will not be there.
Commission is there, will proceed. Commission has now filed an affidavit. Anyway,
The management is least bothered actually about it. They want this to happen peacefully. They don't want
absolutely,
anything.
absolutely, yeah, but should not be.
They should not, because it's a stigma against them, against the company also.
Absolutely. And it's been due for some time now. আর বুধবার দিন আছে তো ওটা একটার থেকে আছে ও আমাদের থেকে then I can fix it on 16th as well. Just find out. Okay, very well. So for you, 17th. ঠিক আছে এই তুমি এগুলো গুছিয়ে দিও একটা শুধু কাগজ দেখতে পাচ্ছি না ও না দিয়ে দিয়েছে সবকটাই আছে তুমি দেখে সবকটা গুছিয়ে
3:30.
But that day will be a light day. I'm sure that those 2 days will be light days. They can.
Now everyone is concluded only for Mr. Sharma.
15 minutes is
3:30 Corona, make it 3:15, make it 3:15. Otherwise,
অর্ডারটা কম করা আছে অর্ডারটা ঠিক না ওটা এটা আগে দিয়ে দিচ্ছি তারপরে হয়ে গেলে তো নেবো at 3:20. So it will be, there is another matter fixed at 3:30. So I'll give maximum 10 minutes for Mr. Sharma. What, any response, he rejoined, what more you will learn? This is all good thing.
confidentiality.
3:15 করে দাও